May it please your lordship. My sincere apology, my lord. I have to seek an adjournment in the matter. There have some personal difficulty today, lordship.
Just record. Why it has been listed today? This is not the regular day to take up an appeal.
I understand, lordship. There was some personal difficulty. I could not come, and this is not in my. This is the fourth round of litigation in the matter. I have to appear personally to do it, my lord. That was the restriction, my lord.
Judicial order.
Oh. It was on my request the matter was listed, my lord, on that day, my lord.
Okay.
Can it be on 2nd of July, lordship? Lordship permits, my lord.
2nd of July is we can't take up hearing. It's just before the 1 day before vacation. We'll not be able to take up the hearing.
Lordship.
Goes after vacation.
After vacation, lordship.
Those will be motion days. We'll not be able to take up final hearing.
Lordship. After vacation, lordship.
Mr. A. Lal and counsel for the petitioner for the appellant to praise for adjournment, as he could not. Praise for adjournment. Next, Mr. M. Katulana, DSG is present. Most of the matters is adjourned today. List on. Give a date after vacation on a regular.
21. May I, Your Lordship? Lordship, I beg to mention item number 10 and 11, Your Lordship. This matter to be listed on this 22nd of June, Your Lordship.
You're taking consent?
Yes, Your Lordship, I've taken consent, Your Lordship, from the petitioner.
Consent on the other side. The committee advocate prays for adjournment. Prayer is allowed. List on. When do you want?
22nd, Your Lordship.
Okay.
And also, Your Lordship, item number 14 and 15, Your Lordship.
14 and 15 is for orders. Why it has been listed for orders?
We have already filed our counter affidavit, Your Lordship.
Madam, readings are completed, madam. Complete, madam.
Readings are completed.
Madam. Here, my lord, I am for the petitioner in about the cases, my lord.
14 and 15, both sides are represented. It is submitted at the bar that the case is reading in regard service and the readings are also exchanged. First, on the prayer made by the government advocate, the matter is adjourned today. List on. We are listing it after vacation so that we can.
Malad, may I pray that, Malad, this is on Malad, this small issue, Malad. Just 2020 matter, Malad. One is 19 matter. So, Malad, may I pray that, Malad, on 18 Malad of this month, Malad. As consented by the other party, Malad. On 18 Malad.
Okay, 18/6/2026. Okay.
Oh, may I also item number 29, Your Lordship. This matter to be listed after a week, Your Lordship.
This is regard to LPC, right?
Yes, Your Lordship. In this matter, Your Lordship, additional senior government advocate G.A.T. is appearing. He is not present today. Yes, 29.
Just show me that record. I forgot about it. Mr. Kanduk is here. No.
Yes, I have taken concern here. I've informed Your Lordship.
No, for different reason. Okay. With consent of the other side, the Learned Committee with praise for adjournment, prayer is allowed. List on when,
This after a week, Your Lordship.
give a date, fixed date after a week.
17 June.
Overlies, Your Lordship.
Yes.
Lordship, I beg to mention item number 28. Here, Lordship, leading counsel Mr. P. Tapo is out of his station. Kindly matter may be adjourned.
It's a 2021 matter. Okay, he's out of station. Okay. Both sides are represented on the prayer that the Learned Council for the holding the brief for the petitioners is out of station. For the matter is adjourned today. List the matter again on. Give a date for hearing.
1 week after 1 week. 2 weeks, 24 June.
Okay, 24 June.
Much okay.
May I please, Your Lordship? Lordship, I beg to mention unlisted matter of WPC repetition for listing today, Your matter is for withdrawal of the repetition, my lord.
For withdrawal.
Yes, my lord.
Okay.
Like Your Lordship.
Item number 1.
My lord. May I, my lord? This is my contempt petition, my lord, for violation of judgment and order dated 11/2/26, my lord. Page 26 would be the relevant portion, my lord. By committing fraud, my lord, here the authorities has misled us, my lord. So why we have filed the red petition, my lord. And this judgment, my lord. Page 26, the relevant portion will be pair 28, my lord. This district administration, respondent number 3 has done his duty, my lord. The respondent number 1, my lord, is unnecessarily holding the file, my lord. We are following the file, my lord.
Okay.
I pray, my lord, respondent number 1 may be called in person, my lord.
Mr. B. Pichara, counsel for the petitioner, alleging non-compliance of the order dated 11/2/2026. And alleging that the respondent number 1 is has held up the relevant file, the present contempt petition has been filed under Section 12 of the Contempt of Courts Act and with Article 215 of the Constitution of India. Issue notice returnable on so. Give a date after 4 weeks. The petitioner shall take steps within 2 days for service of notice on the respondents by speed post with AD.
If pilot permits personal attendance of respondent number one, my lord, I will
Not
take
now.
that step, my lord.
Let us first hear them if required. Next, the respondents of notice that as no order has been passed for dispensing with their personal appearance, the respondent shall ensure that their affidavit is filed prior to the next date of listing. Next, the pendency of the contempt petition shall not be a bar for the respondent authorities to comply with the order of this court dated 11/2/2026 passed in WBC 271 of 2024. List also is.
My lord. Well, I have alleged against respondent number one in my para 6, my lord. With ulterior motive, my lord, he is withholding the file, my lord.
No, that's okay, but we'll have the response first.
My lord.
Item number two,
Obliged.
Wait, my lord, item number 2 and 6 are connected. If your lordship kindly take up item number 6, then I don't have to bother your lordship with the same set of documents. Now. And if your lordship have kindly page 92 of the writ petition, item number 6,
92.
92.
Yes.
My lord, this is an order issued by the Deputy Commissioner East Siang District, Pasighat, by which the petitioners who are Gaumburas of Mayor Village were suspended for a period of 8 months as a way of
It was set
punishment.
aside. This order is set aside.
This order is set aside. In spite of that, my lord, they proposed to my lord, if your lordship may kindly have, we have reminded them on 2 occasions. Your lordship have the impugn order at page 105. The direction was to reinstate as forthwith, my lord.
Yes.
In spite of that, now the deputy commissioner wants to rehear the matter, my lord.
Page number?
Page number 105. As desired by the competent authority, a hearing is hereby fixed on 27th in connection with suspension of 2 Gaumburas of such and such subdivision East Siang District. Therefore, you are hereby directed to appear in person on the stipulated date and time positively. But how can he do that now, my lord?
In item 6. Yes.
yes, my lord. This suspension order, my lord, it was passed in September and this May, my lord, it is already been
That
expired.
period also is over, my lord.
Expired, my lord.
The period of punishment.
No, but look at the order at page 105.
Yes, my, I've seen, my lord.
First line.
Yes.
Yes, my lord. As desired by the company, the hearing is fixed on 27th
desired.
of May. Yes, my lord.
Now, after this, who will desire? It
That's
can be
fine.
only the desire of the division bench
Yeah.
or the lordships in Supreme Court.
Yes, your honor.
Any other desire, should we follow that? No. And Mr. D.K. Bangi, Madan Senior Counsel, assisted by Mr. Miss, I forgot your name. And counsel for the petitioner. Petitioners. Next, the case of the petitioners is that by an order dated 24/9/2025, page 92, the petitioners who are the respective Gaumburas were suspended
Yes.
for a period of 8 months from the date of the order. Most of the said order dated 24/9/2025 was set aside by this court by a judgment and order dated 1/4/2026, passed in WBC 571 of 2025. By directing the authorities to reinstate the petitioners in their post as Gaumburas forthwith. Next, the Honorable Senior Counsel for the petitioners has submitted that in an attempt to overreach the said judgment and order dated 1/4/2026, the Deputy Commissioner East Siang District, Pasighat, purportedly on the desire expressed by some competent authority, had fixed the matter for hearing on 27/5/2026 regarding suspension of the petitioners as Gaumburas. Accordingly, they said order dated 19/5/2026, page 105, number so and so, dated so and so, is assailed by filing this writ petition under Article 226 of the Constitution of India. Next para, issue notice returnable on so and so. As Ms. T. Mahmood and Government Advocate accepts notice for all the respondents, or requested extra copies of the writ petition be served on her in course of the day. Next para. The prayer for interim relief is opposed by the learned Government Advocate. First of considering that the petitioners have been able to make out a prima facie case that by the impugned order dated number so and so dated 19/5/2026, the Deputy Commissioner, East Siang District, Pasighat is attempting to overreach the judgment and order dated 1/4/2026, passed by this court in WBC 571 of 2025. The proceeding initiated by impugned order number so and so dated 19/5/2026, page 105, is state for all intents and purposes. Full stop. In other words, the Deputy Commissioner, East Siang District, Pasighat, is prohibited from taking any steps which would run counter to the said order dated 1/4/2025, passed by this court in WBC 571 of 2025. Next, the petitioners had caused production of a certified copy of the order before the office of the respondent number 3 to bring the order to the notice of this said authority. Next para. As the respondent number 3 is also represented by the learned Government Advocate, we request the learned counsel for the petitioner to provide a photocopy of the certified copy to the learned Government Advocate, who on receipt of the same shall communicate the same to the respondent number 3. List on so and so.
My lord, can it be before the vacation, my lord? We have, even our punishment term is already over, my lord. The 8 months, my lord, that also automatically has now been over. Can it be listed before the vacations?
3rd July, my lord,
Not 30, not there one.
last day.
I'll furnish the copies today itself. Any date on 29, 30, my lord?
Okay, 29th, make it.
29.
And the contempt petition First part will be same. So she will not be there. Alleging willful disobedience and non-compliance of the order dated 1/4/2026 passed by this court in so and so, and in order to overreach the order of the court, comma, the respondent had stated to have issued where is that order here? Where is that order here?
Page 25, ma'am.
Comma, the
25.
respondent has issued the order dated, page 25 dated so and so 19/5/2026. The present contempt petition has been filed under section 12 of the Contempt of Courts Act, article 215 of the Constitution of India. Issue notice returnable on so and so. The petitioner shall take steps in course of day for service of notice on the respondent by speed post with AD. Moreover, the petitioner shall also cause production of a certified copy of the order, shall serve a copy of the certified copy of the order before the office of the Deputy Commissioner, Siang District, Pasighat. Next para. The court has taken note of the fact that taken note of the contents of the judgment and order dated 1/4/2026 passed in WBC 571 of 2025, that by an order dated 24/9/2025, the respondent had suspended the petitioners for 8 months which was interfered with by the order of this court dated 1/4/2026. Most of the said suspension period is already over by 23/9/2025. And therefore, not there. However, the petitioners have not been reinstated despite lapse of the period of suspension by the order dated 24/9/2025. And there is also willful disobedience to the order dated 1/4/2026 by not reinstating the petitioners forthwith. Next, therefore, the respondent is put to notice that her defense, she's a lady,
Yes.
defense would only be accepted after the respondent purges of the contempt. By taking appropriate steps as directed by this court by order dated 1/4/2026, referred above. Next paragraph. As we find that the respondent has made an attempt to overreach the orders of the court, she is put to notice to appear in person to show cause. after purging of the contempt. Next, list on so requiring personal appearance of the respondent.
Item number 3.
Please, Lordship.
Yes, Mr. Lolin.
Lordship, this is regarding non-disbursement, non-release of my 3-month salaries, Lordship.
May I, Your Lordship?
Yes.
Your Lordship, in this matter, in earlier, Your Lordship, sought instruction. We have received the Parawise comment today, Your Lordship. So we'll file our counter affidavit, Your Lordship. In this state, today, Your Lordship, notice may be issued, Your Lordship.
No, but can I look at your Parawise comments?
Parawise.
Can I look at the Parawise
Oh,
comments?
Parawise comment. Yes, Your Lordship. Emang right na?
Yes, officer will be in difficulty.
Yes,
With these comments, he will be in difficulty.
yes, Your Lordship. It's not clear.
You know why? You have read it.
Yeah, I have read it, Your Lordship.
You have read it.
Yes.
Right.
Not clear. Clear need.
Then give him your advice. With this affidavit, he'll be in deep trouble.
सुनो ना, आपको बोल रहा है.
Correct? Mr. K. Rowland and counsel for the petitioner. Next, Ms. P. Pangodan, government advocate. Prays for, has submitted that she has received Parawise comments and prays for some time to file an affidavit. Next, para. Issue notice returnable on, how much time will take?
Your Lordship, at least 1 week, Your Lordship.
Okay. Returnable on 22/6/2026. So the affidavit of the state shall be filed by then. Next, para, the pendency of the petition shall not be a bar for the respondent authorities to release the subsistence allowance due to the petitioner. For the period claimed. List on so.
Can it be fixed, Lordship, on 18th?
18th will be difficult. Matters have already been fixed.
Then 22, Lordship.
22.
22.
Okay.
22, we have given the date 22 only.
Obliged, Your Lordship.
Deeply obliged.
Item number 4.
May it please, Your Lordship. Your Lordship, the petitioners are before this honorable court, being aggrieved by the rustication, as well as for denying to issue the transfer certificate of the petitioners, Your Lordship, along with all other original documents that has been kept in the custody of the respondent school, Your Lordship.
Yes.
Now,
What
the
is it
problem
exactly?
is,
What is the difficulty for a student to have transfer?
my lord.
What is the difficulty for the authorities to transfer a student from one school to another?
My lord, there is a my lord, the provision as per the society, my lord, wherein my lord, in the mid of the my lord, the situations, my lord, if it is
No,
what
he is
is,
going at his own risk. What is the difficulty of the school to raise the person?
yes, my lord. My lord, as per the instruction, my lord, they are ready to issue the TC. However, my lord, the provided that other my lord, the terms and conditions which has been prescribed in the rules has to be followed, my lord.
No, no conditions. Why
Well,
a
this is the
student wants to
instruction,
leave the school, why not?
My lord, this
Your
is the,
Punish, can you punish the student?
my lord,
No, if
there are be, my lord.
if there is any such rule which prevents a student from taking a transfer, that has to be quashed.
To be, my lord. It is clearly mentioned, my lord.
Was it appropriate for the authority to give you comments like this? They could have, they know that there is a writ petition. They could have issued a transfer certificate. They are waiting for the court order. If they are waiting for the court order, we settle them with cost.
My lord, on the last occasion, my lord,
You see, they are saying that we are ready to give. If they are ready to give, why they did not give it? So they are waiting for the order of the court.
my lord, the only issue is, my lord, as per the my lord, my lord, we, my lord, intimated to the
So you ask
parents.
them, you call them up and ask them for the intimation. If they are going to do it of their own, let it be done by when we resume at 2 o'clock. Otherwise, there will be a cost imposed of 50,000 rupees. We are putting you to notice. You can ask them to look at the online video of this proceeding. Ask them if they voluntarily do it, a transfer certificate, issue a transfer certificate, well and good. Otherwise, cost of 50,000 to be realized from the headmaster or the principal of the school, whoever he is.
Well.
Tell them
My lord, at 2 p.m., madam.
at 2 p.m. If they do it voluntarily, well and good. Otherwise, cost to be realized from his salary.
Well.
This can't be permitted. A student wants to leave the school, he is living at his own risk. Does the transfer certificate assure him admission elsewhere? Please tell me,
My lord,
if I want to withdraw my son today from a school,
my lord.
will that transfer certificate assure me admission in another school? No. Then what is the difficulty in the headmaster or principal issuing the transfer certificate?
My lord, as per the my lord, the instruction, my lord, they are ready, my lord. However, my lord, the rules has to be followed, my lord, by.
We'll issue an order with a paperweight.
Wait, please, Your Lordship.
Otherwise, orders will
Your
fly
Lordship,
away
even the rules
Hello.
does not apply in this case, Your Lordship.
At 2 p.m., my lord.
at 2 p.m.
Deep level.
Item number 5.
Please, ma'am.
Lords, if I may,
Yes.
yes, with the Lordship's kind permission, my lords. I have 4 primary submissions to make right at the outset, my lords, because we are challenging an order of termination followed by an order of debarment. The 4 primary submissions are, my lords, that the order of termination followed by the order of debarment, my lords.
At this stage, we are not inclined to issue an interim. We'll put
Yes.
them to notice and then on the next date, we'll consider.
Lords, we are on because it's an order of debarment, and the order of debarment, my lords, is actually, it's absolutely void. That's my submission, and that is why, my lords, we are insisting on the interim preamble. I'll show to my lords.
Because because of the status of the work.
Lords, very well, my lords. If I may just tell my lords, there were 2 contracts. The contractor is what is called an EPC contractor, my lords. Your lordships are aware, which is called an engineering, procurement, and a construction contract. That is done by the contract. I have nothing to do with that. I am not the EPC. I am only roped in or hired as a consultant. So my job, my lords, is only to advise and my lords, to give whatever corrections I may be asked to, only limited to the role of a consultant or an advisor. My lords, the termination is passed against the EPC contractor, the person executing the contract. There is no debarment against that gentleman. But I am terminated and then subsequently debarred.
Because under the, whatever little I could understand.
Yes, my lords, please.
The consultants have the ultimate liability of the smooth completion of the work. That is what I gather.
My lords,
May be wrong because
I will show to my lords from all the documents, my lords. My role is only in the capacity of an advisor. Insofar as execution, measurements, payments, these are all joint exercises. My lords, the contractor in question, my lords, suppose completes the work, and then that work is to be examined, inspected by me, and of course the officials of the respondent corporation. After, my lords, it is jointly approved by all of us. And it's all on record. Not a single measurement is, my lords, disputed. They are all on record. They have all been approved, ratified, my lords, inspected by me and the officials. And, my lords, subsequent to the termination of the EPC contractor, a new EPC contractor was appointed. And that gentleman, the new EPC contractor, also accepts the measurements and, of course, the percentage of work completed till that date. So, my lords, there is no dispute on that part. But I am still debarred. The original contractor is not debarred, and my lords, and blacklisted. My lords, your lordships have settled on right from Gorkha, Eurasian equipment, and everything, my lords, that blacklisting is ultimately the civil death of a contractor. You've actually, for all purposes, annihilated the judgment. So, my lords, there has to be subjective application of mind. There has to be evidence in support. There has to be a complete reasoning, and of course, the power to terminate or to debar. My respectful submission is, my lords, here in this case, the respondent does not enjoy that power. There is no power under our consultancy agreement, my lords, whereby the respondent can either terminate or debar the contract. It's not there under our agreement. That's what I was submitting.
As per the notice issued at page 135.
Yes, my lord.
Referring to clause 2.8.
Yes. So I could, if lordship agrees, I'll just show my lord those clauses, and your lordship will see that there is no power on this on the department to, my lords, terminate or debar. The only thing they can do is, my lords, issue a show cause, ask me to provide an explanation, and yes, if for some reason they are unhappy with that explanation, therefore a dispute emanates, my lords, then it has to be referred. But they themselves, until the time a decision is taken, my lords, by the adjudicatory authority or whichever, my lords, the arbitrator, till that time the contractor has, the contract will remain in operation. Nothing will change vis-a-vis the contract. This is the specific provision of the contract, my lords. That till that issue is decided, whether or not, my lords, it calls for a debarment, it calls for a termination, whatever it might be, my lords. Till that time, the contract will continue as it is. There will be no change in the status of the contract. And, my lords, the show cause notices, there are two show cause notices. My lords, if I may just, since your lordship is hearing me, my lords, may I then make good my submissions, my lords?
Yes.
There are two show cause notices issued by the department. Both of them are replied by me. My lords, followed which the order of termination comes and then the order of debarment. None of the reasons propelled by me are even considered. Both this order of termination and debarment is mere copy-paste of the show cause notices. Whatever allegations are leveled against me, my lords, in the show cause notices, they are then repasted in the termination and the debarment order. There is no application of mind whatsoever as to this is my answer, whether there is merit in that answer, my lords, whether there is any truth in that answer, nothing whatsoever. Then, my lords, the third is they rely on an anonymous letter. I say, please give me a copy of that anonymous letter so that I can respond. That letter is not provided to me, my lords. Your lordships have held not once, but 100 times in any quasi-adjudicatory proceedings, if you are relying on any document or on any evidence, my lords, on which you predicate your decision, that evidence or that document or whatever that may be has to be, my lords, provided to the party that you are accusing of. That is not provided, my lords. And then, of course, comes last, my lords, you've taken the most severe form of punishment. You've blacklisted me for all purposes, my lords. I have 80 projects today going on in the country. I have more than 50, 80 bids that I've already applied for, my lords. Thousands of people work for me. My lords, we are shut if this order, my lords, comes into operation. We are shut for all purposes. So that is why I was saying, my lords, let them file a reply, no issues. That interim protection may be granted to me. And then your lordships may hear us, my lords, ultimately.
Where is the termination clause?
Yes, my lords. If your lordship will just permit me, lords. My lord. Please, my lords. Your lordship will have the consultancy agreement, my lords.
Page.
Yes, I'm just giving my lords that page. Lords, it starts at page 47. And the relevant clause, may I just show to my lords? Yeah. So look, it starts at page 70, if my lord takes that.
Yes.
Yes, my lord, we'll see 2.9 is the termination by the client. Client here means the department, my lords. And these are the various clauses by which they can terminate. Then, my lords, may come to the next page, page 71, 2.9.1. So 2.9.1 is the 2.9.11. The 2.9 is the termination. 2.9.11 is not termination, but you're put in a negative list, my lords. Then your lordship will kindly come to the next page, page 72, 2.9.2, where it's by the consultant. The consultant also has a right to terminate, my lords. And then, my lords, will kindly have at 74, 2.9.6. Kindly see, my lords. At 74, disputes about events of termination. If either party disputes whether an event specified in paragraphs A to E of clause GC 2.9.1 or in clause 2.9.2 hereof has occurred,
Then
such
arbitration.
party may within 45 days after receipt of notice of termination from the other party refer the matter to arbitration pursuant to clause GC 8 hereof, and this contract shall not be terminated on account of such event except in accordance with the terms of any resulting arbitral award. And then, my lords, kindly see, and debarment is 2.9.7.
But then you'll have to go for arbitration. Why
No,
would
my lords,
you mention it?
arbitration is if, well, it's at the stage of the notice, that if there is a dispute at the stage of the notice, it has to be referred to arbitration. But he's proceeded, my lords, they've gone ahead and terminated and debarred me without referring it. And then, my lords, kindly see at, may I just show to that, my lords, at page 86, my lords, is where the arbitration clause is.
No, notice of termination is after termination.
No, notice of termination is the show cause, whereby they ask us to reply. And then we reply. Notice of termination is nothing but the show cause, my lords. And after that comes, of course, the termination order. So, my lords, kindly see at 87. This is very important what I want to show to my lords. 87, my lords, your lordship will see clause 8.4.4.
Page 80.
87, my lords, 87. 87, my lords. My lord has?
Yes.
Yes, my lords. 87, your lordship will see 8.4.2a, where the arbitrator has to be somebody from the Indian Roads Congress. Then your lordship will kindly see thereafter, my lords, 8.4.4, where the qualifications are prescribed. The sole arbitrator hereof shall be an expert with extensive experience in relation to the matter in dispute. Then, my lords, 8.4.5, the arbitrator shall make a reasoned award. Any award made in arbitration so-and-so shall be final and binding. And then most important was 8.4.7. The agreement and the rights and obligations of the parties shall remain in full force and effect pending the award in any arbitration proceedings hereunder. So, my lords, even at the notice stage, when you issue me a show cause and you refer the matter to arbitration, there is no proceedings for termination or debarment contemplated, my lords.
That is a well-settled law.
Yes, my lords. So therefore, my lords, you do not refer. I ask in my reply, I say very well, refer the matter to arbitration. You jump that, my lords. May I just show that? If
Yes.
your lordship will just take that. At page, my lords, 144, my reply starts. Otherwise, at it otherwise starts at page 135, my lords. And kindly see at page 144.
Just a moment.
I'm so sorry.
Where did you say which page was that arbitration clause?
Sure, my lords. My lords, that was at page
74.
86, and then 87 was what I was
So
reading.
that 74, that within 45 days.
Yes.
2.9.6.
Yes, that's 2.9.6. That's the termination clause. this arbitration.
And then next page you showed is page number?
Well, this termination is 70 millions, both by the first by the party, meaning the department, and then by millions, the consultant, which is at 72. Then millions, I showed to millions at 74 when the disputes emerge.
Just a moment.
Yes, I'm so sorry.
Page 74. You
Yes,
showed,
my lord.
then-
Yes, 2.9.6.
Then page number?
And then, my lords, I showed to my lords the arbitration clause at page 86 and then 87. The very responsible, my lords.
Okay.
Function assigned to the arbitrator. One, he has to be an expert from the Road Congress.
Now which document now you are showing us?
Yes, my lords. So this is, there is, and then, my lords, at kindly see at page 144. This is my reply to the show cause, my lords. The reply starts at 135 my lords, and I'm coming straight to 144. My lord has, my lord?
Yes.
144 my lords at the top of the page. Where after, my lords, we give all our replies to the show cause. Kindly see, my lords, we request to immediately withdraw the notice of intention, request to initiate an independent investigation by either a CBI or so and so forth to establish the facts and identify the true cause of delay or misreporting. If the dispute continues, we request resolution to arbitration under clauses 8.1 and 8.2, and then issue such notice to declare so and so shows malafide intention and so on and so forth. And then, my lords, kindly see at the bottom of this page where all this, my lords, or measurements, this, that, my lords, everything, whatever the dispute is, kindly see with physical photos of visits of executive director projects, general manager projects, general manager technical, DGM projects during the handing over and taking over the charge with reference letters, my lords. We request to investigate the matter from any agency for a fair and impartial to the knowledge of all, my lords, and these copies are marked to the various, my lords, highest officials. And these are all from NHIDCLs, all various officials of the NHIDCL, my lords. So, my lords, I am submitting very simply, my lords, that one, my lords, under our own agreement, you do not enjoy the right to terminate. Both of us by contract have decided that in the event of a dispute, it shall be placed before an expert. The moment you decide, my lords, that a notice will be issued asking you to show cause. At that stage itself, it has to be, if the other party, my lords, disputes it, you have to refer it to an expert, my lords, to decide one way or the other. And of course, once the decision is made by the expert, whether to terminate or not to terminate, my lords, that is one issue. Two, my lords, till that decision is taken by that expert, the agreement will continue to
Agreement is only for the arbitration clause. It's the other effective agreement will not be binding. It is only for the arbitration clause that it survives.
No, my lords, kindly see that. It says the agreement will continue as it is.
It's continued because the arbitration clause, even if it is not there, then there are just.
No, my lords, I was just showing, so my lords, kindly see two things. 84.
No, that is only for the arbitration clause. You know the law.
Yes, my lords, but
Then
and then kindly
Supreme Court has
take one
clearly
moment.
directed that even our court has directed that once there's once an arbitration is invoked,
Yes, my lords,
that will survive for the purpose of arbitration.
I agree. But the two things I wanted to show to my lords, in both the clauses, it is very clear.
We know that. You have already showed us that.
Yes, my lords. This contract shall not be terminated on account of such event except in accordance with the terms of any resulting in the arbitral award. That is all I was showing, my lords. That till the arbitral award comes, there will not be a change in status quo.
Who is the CGC here? Nobody is there.
And my lords, in my
The
petition,
NHIDCL doesn't have a standing council? No. NHIDCL? No. No standing council.
No, we don't have.
Mr. Mao, is there a standing council? There's no standing council.
There's no standing council.
They engage after the case.
After notice is issued, apparently.
Okay. Mr. P.K. Chaturvedi,
No, my lords, I am M. Datta.
M. Datta.
Mr. Chaturvedi is with me, my lords.
Okay, Mr. M.
He's
Datta,
instructing me.
counsel for the petitioner. aggrieved by number one, show cause notice dated 22/4/2025, comma number two, letter of intention to terminate dated 8/7/2025, comma, and termination order dated 20/4/2026. By which the petitioner was the consultant for the contract work of is the contract
My lords, it's at page 22, your lordship will find that at the
22.
termination order, my lords, right at the top. Construction of high altitude hill road, so and so.
22.
At 22, right at the top, my lords.
Okay. Page 22,
Yes, my lords.
subject.
Yes.
We have a pencil mark. The present writ petition has been filed in Article 226 of the Constitution of India. As per the Learned Counsel for the petitioner has submitted that person to the letter of intention to terminate dated 8/7/2025. The petitioner company had submitted the reply. This is a company or joint venture?
Joint venture. Joint venture.
The petitioner, which is a joint venture entity, has submitted a reply dated 8/8/2025. Whereby they have invoked resolution through arbitration under clause GC 8.1 and 8.2 of the contract agreement. So it is submitted that without resorting to arbitration, the respondent has, where is the termination order?
Please, my lords, page 22.
And issued the termination order number so and so, page 22, dated 20/4/2026.
My lords, which is followed by the debarment order of 15th of May. That's at page 27. The blacklisting order.
Followed by a debarment notice number so and so, dated 15/5/2026, page 27. By which the petitioners have been made ineligible to participate directly or indirectly in any tender process floated by NHIDCL or Ministry of Road Transport and Highways in accordance with the capital M, small o, RTH circular number capital RW oblique NH-33044 oblique 76 oblique 2021 dash S symbol and R within bracket PNB bracket goes dated 7/10/2021, page 33. The petitioner filed this present writ petition on Article 226 of the Constitution of India. Issue notice, including notice on the prayer for interim relief, returnable on due date after 4 weeks, returnable on so and so. This petitioner shall take steps for service of notice on the respondent by speed post with AD. Post of the Land Council for the petitioner is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Next para. The petitioners are also serve notice on the respondent through thus the mode by routing the process through the registry of the court and upon service at the address given in the cost title, affidavit of service shall be filed prior to the next date of listing. Next para, as an interim measure until the next returnable date, the termination order number so and so, page 22, dated 20/4/2026, shall remain suspended. List on so and so.
May just add the termination and the debarment order, Manoj. Because without the debarment, Manoj, I can't do anything.
We have stated only the debarment, not the termination.
But your lordships have said termination. I've said termination and debarment. That's all I'm saying.
No, page 22 is that. Oh no, it is 27.
Yes,
No,
27,
we are
Manoj,
saying that
22,
27.
Manoj. Yes.
We are saying that the debarment notice. That will be page 27. Debarment notice 10/15/5/2026.
Yes, that's fine. I'm so extremely like.
22 July. Huh? Item number 7.
Great.
Please, my lord.
Yes.
My lord, I'm before this honorable court for the illegal acquisition of my private land by the respondent authorities without following the due process of law. In this regard, I have submitted the representation also.
And your lordship, government has already replied the representation, your lordship, submitted by the petitioner.
May I kindly come to page, my lord, I'll take my lord to page number 74, my lord. This was my first representation.
In this, you have produced a give deed, correct?
Yes, my lord.
Now,
If I may, my lord, what happened?
just a moment.
Yes.
Right.
Yes, this is that page 62. Here you have annexed that a person has donated that land.
Yes, my lord.
And pursuant to that, a notification has been made,
Yes, my lord.
correct?
Yes.
Now, there's no dispute with regard to that document.
My lord, I'm My contention is that, my lord, this document, this 20 landowners, this was in agreement with the private respondent number 5, who was interested to execute this project, my lord. And accordingly, he came with an arrangement with this villagers and donated the land for. You know,
You see, this person, whatever source he has for the ownership of the land,
yes, ma'am.
the respondent number 5, he has given the gift of the land at Annexure 6. And then Annexure 7, there's a notification of construction of the central jail.
Yes, my lord.
Now, so far as this document is concerned, Annexure 6, there is no challenge.
No, I'm not challenging.
Correct.
this. Yes.
And you can't challenge it in the writ petition because it will be a private dispute between you two.
Yes, my lord. I completely.
Then please tell us why we should issue a writ. It should be dismissed in limine.
My lord, may kindly come to page 73, my lord. This was the meeting. After.
Forget about the meeting.
Yes.
The notification is based, page 63 notification is based on page 62. There is no challenge to page 62.
Yes.
You file a civil suit. This not be adjudicated here in a writ petition.
I'm challenging here the conduct of the private respondent with
Absolutely
the
right.
with the government. my lord.
Absolutely right.
Yes.
Respondent number 6 said donated the land. How can you challenge that in a writ petition?
Well, the
Conduct.
the process, how this process was started, my lord, in 2021. On the same day, the land possession
See,
certificate was
is there
issued.
any law which prohibits me to donate what you call the, let us say, Mount Everest to A? Is
No.
there a law prohibiting me?
No, my lord.
If I do it, it will only be a fraud on the person who will do it, who has done it.
Yes.
So that action nobody has challenged. My donating of Mount Everest to Miss Pangu.
I agree on that, my lord. But the process,
So
how
will be,
it was undertaken by the.
sale deed would be a nullity, will be illegality. But that challenge has not been made here. So conduct, why should we look into the conduct?
The private respondent who has donated the land possession certificate was issued on the behest by the private respondent, my lord, without my knowledge. At least they should have followed the due process while allowing the
Is the High Court
allocating the
is the High
LPC.
Court an appropriate court to look into this dispute?
Look, my prayer is very limited with regard to the compensation,
No,
which
here
was
is very limited, but tell us our jurisdiction. What will you do? We'll call the people here, have the witness taken. You know, in the High Court, we don't have the original jurisdiction.
yes, my lord.
Then how will you decide that issue of title? You'll file a civil suit.
The title is not disputed, my lord, though. Being it's a government has acquired the land for the public purpose, my lord.
You see, you will be in difficulty in making that statement because we will record it and then your right even to before the Supreme Court will be curtailed. Just from the trial court till Supreme Court, your right will be curtailed because we'll make a statement here in the order
Yes, my lord.
that there's no challenge to that. Once there's no challenge, then you know where you are hit. Order to Rule 2.
Yes, my lord.
It will create a bar against you for all times to come. So therefore, we are
If
just closing it without making an observation. Otherwise, it will.
if my
Cause you
lord may come
prejudice.
to page 74, then subsequently a notice was issued, man. Page 76 by the respondent number 4, man. 3 to 4, my lord. Page 76 is the
76.
forwarding. Yes, my lord. Page 74, I filed my first representation, my lord.
No,
I've
it's okay.
submitted. Then
Whatever they do,
76,
but we
yeah.
are now looking at the legal challenge. We have given you sufficient indication, but if you want to argue, you can argue the matter. You are at liberty to do so.
Oh, my lord, in that case,
It will cause you prejudice. That's why we are saying.
yes. In that case, my lord, then observation may be made to proceed appropriate court, my lord.
Yes, we'll do that. But Mr.
S. Chetri, my
S. Chetri, learned counsel for the petitioner, and Ms. P. Pangul, learned government advocate for the respondent numbers 1 to 4.
Yes, Your Lordship.
Having heard the learned counsel for the petitioner, the court is of the considered opinion that as the impugned notification dated 7/3/2022, bearing number page 63, bearing number so and so, has been issued pursuant to a gift deed dated 4/2/2022, made by the respondent number 6. The issue raised by the petitioner claiming ownership of the plot of land would be a dispute with regard to the ownership of the land as between the petitioner and the respondent number 5. So therefore, the court is disinclined to entertain the writ petition where a disputed question of fact relating to the ownership and right of the respondent number 5 to transfer the land to the state would be very relevant. Of which of such a dedication is not desirable in a writ petition filed under Article 226 of the Constitution of India, where there would be disputed questions of fact to be decided. Next para, accordingly, without entering into the merit of the matter and without any prejudice to the petitioner, the petitioner is delegated to approach the appropriate court of the authority with liberty to raise any ground that has been taken in the writ petition. Next para. With the aforesaid observation, this writ petition stands closed with liberty as indicated above. So this will not cause you prejudice now.
Obliged, Your Lordship.
Item number 8.
Yes.
My lord, if it pleases Your Lordship, this matter can be disposed of, Your Lordship. This matter can be disposed of.
Yes.
Yes, Your Lordship. My lord, the respondent authorities, they have also considered in their affidavit in opposition, Your Lordship.
They've considered your
Yes.
to your prayer.
Yes, Your Lordship.
Where is that?
At paragraph, in their affidavit, at paragraph number 6 and 7.
Para?
Paragraph 6 and 7, page number
6 and
43.
7. Ms. D. Tamuk, Learned Counsel for the petitioner. And Ms. P. Pangu, Learned Government Advocate appearing for the respondents. Next, agreed by the order dated, order number, you'll get at page 14. Order number dated 16/11/2022. Issued by the Deputy Commissioner, Shi Yomi District, within bracket respond number 3, by which the petitioner was dismissed from the post of Gambura of Charu village in Shi Yomi District. The present date petition was filed under Article 226 of the Constitution of India. Next, in the rate petition, it is projected that the petitioner was dismissed from the post of Gambura without giving any opportunity to the petitioner of being heard. Next paragraph. The Learned Counsel for the petitioner has referred to the affidavit in opposition filed by respondent number 3. Stop. Next, as per in paragraph 6 of the said affidavit in opposition, the respondent number 3 has accepted that the dismissal was not in accordance with law and opportunity of hearing was not given. Accordingly, it has been admitted that it was erroneous on part of the Deputy Commissioner, Shi Yomi District, to have not followed the procedure. Stop. Next, accordingly, the Learned Government Advocate has submitted that in view of the said admission, the petition can be closed. Stop. Next, but something strange is happening here. You have seen your affidavit.
Yes, Sir Lordship, I've seen.
Come to page 2, read paragraph 1. You've seen paragraph 1 of your affidavit. You see, it may land people in trouble.
Yes.
The wrong was committed by the Deputy Commissioner.
Yes, Sir Lordship. The
Deputy Commissioner does not come and admit that he has made a mistake. A subordinate to him, an Assistant Commissioner, who is a rank lower to the Deputy Commissioner, comes and says, my boss has committed a wrong. According to you, is it proper? Now, tomorrow, what happens if the Deputy Commissioner comes and issues a show cause notice against the Assistant Commissioner and suspends her or him or whoever, Rome Mille? Then what happens? You see, the government, while filing an affidavit, must take very serious responsibility as a government advocate. You admit this through a rank junior. You can only play that the Deputy Commissioner will not have a scheming mind like I have. immediately. Okay, today will be a prayer day for you. You'll need to travel. For the government, be very cautious while you are filing an affidavit. It may lead to some difficulties somewhere. Next, that's why while we are reading it, it took us some time to understand. Therefore, we have made that statement. Okay. Next, accordingly, in view of the said admission, which was made by the respondent number 3, the repetition stands allowed. The impugned order is at page
Page number,
Hmm?
at page number 40, Your Lordship.
40. The impugned order dated so and so, number so and so, dated so and so, issued by the Deputy Commissioner, Shri Yome District, Tato, is hereby set aside and quashed. Needless to state that the service of the petitioner, namely Sri Takam Ruchi, as Gambura of
Charu village, Your Lordship. Charu.
what is the district? Gambura of Charu district.
Charu village, Your Lordship.
Charu village shall be restored forthwith, and in any event in a period of 3 weeks from the date of the order, first of the respondent number 3 shall come in view of the quashing of the said order dated 16/11/2022 shall pass a consecution order to restore the petitioner as the Gambura of the village referred above. Next, the petitioner shall cause production of a certified copy of the order before the respondent number 3 for necessary compliance. Next, representation is allowed to the extent as indicated above. Next, the parties are left to bear their own cost. Mr. Ratan, yes, the Additional Advocate General will require your presence. I've time and again we have asked the State Council to produce before us an authorization either under the rules of executive business or under Order 30 of the CPC, by virtue of which the government is required to nominate people to have authority to swear affidavits before the court. But I have not got that.
My lord, I think there is a notification that not below the.
No, we always hear that and we accept it since it comes from you.
I will.
But I have not seen that notification. The persons were authorized. You see what happens. That's what I said to Ms. Pangu. That's why I'm telling you. You see, who can be an authorized person? The state can have an authorized person to file affidavits. But supposing you, like in this case, the deputy commissioner is a party. Is that party also has authorized someone to appear for him? Or there will be a straight notification that a deputy commissioner's affidavit can be filed by XYZ?
Notification affidavit.
So government representing and a party representing, a party will have to give an authority letter.
My lord, in this case, it seems the DC has authorized the assistant commissioner to swear this.
Is it?
Not in the
It's not here.
It is for us. We always.
Just
because when the deputy commissioners, they are unable to come themselves, they authorize. So they make specific authorization to the person who swear this.
Okay, then that prayer part I am withdrawing.
Okay, let's. Yeah, I'm pulling it also.
That's okay, that you have an answer. That's okay.
That,
No, that's
whoever
okay.
comes, they are with proper authorization.
No, that's okay. This why we withdraw that
Yes.
statement.
Much obliged, Your Lordship.
Item number 9.
My lord, having seen so many younger friends using iPad and all, they're making it very eloquently. So I also got encouraged. So I also
That is
managed
very
one iPad. And then this is
very
my
wonderful.
first case to do the
Credit
iPad.
yourself. Very good.
We have been using these types of briefs for the last 34 years. So we're finding it a bit difficult.
But this change is always welcome.
Yes.
Yes. Despite this old age, he is adopting to the new.
We have to try.
We can drop a suo motu contempt against you.
No, not so old, man.
Mr. Tony Patina is old. No. You see, when
He's
I had my,
addressing to
you see,
all our generations, my lord.
when I had my first birthday, then also I was told that I was 1 year old. Correct. So old is just a term, but I think you better withdraw it. So after I leave, go to a canteen and then serve him well and then withdraw that.
Yes, with a cup of coffee.
But in fact, had he been in government service, he would have been now retired.
No, that's why he's not. That's why he's not. And he has earned a respect for that, for not being there. Yes, Mr. Patil.
My lord,
But
at the end
Mr.
of the-
Patil, after this, whenever you have time tomorrow, just meet me for 2 minutes in the chamber.
We'll come over around 1.
Yes, whenever you have time, today or tomorrow, just meet me in the chamber for a moment.
My lord, before my learned senior starts, my lord, this is regarding payment of compensation.
Yes.
Here, the requiring body is the Union of India. They have not filed their affidavit yet. Whether it will be proper to go ahead with the hearing without their affidavit.
We can't request people to file affidavits. What you will have to do is, you'll have to provide us with invitation cards, just like that is required to call people in weddings. Give us few copies of the invitation cards, well printed, gilded and all, so that we can send it along with a notice to them to invite them. We offer them lunch, dinner on the state cost.
Mr. Kato has been appearing in this case.
Mr. Kato.
Your Lordship, we have sent the DC to the Ministry for final vetting, and it's still pending there.
But they are not interested. When it comes to land acquisition, the officers know if the affidavit is not filed, the compensation will be granted. We are hand in glove. Is it not? Yes.
Yeah. Yes, already.
But in that case, may I just present my case or else?
No, we give them 10 days time. If they don't file, then we'll hear the matter. We put them to notice. You serve the downloaded copy of this order, and if they don't file, we'll put responsibility on the respondent number 1, and then hear the matter. Respondent number 1 is land management.
In fact, my lord, by the order dated 2/5/25, it was specifically ordered. The notice in this case was issued on 17/9/2024. Matter pertains to reassessment of compensation taking into account the rate of cardamom forest. Both the state respondent 1 and 2, as well as
So then
respondents
we
in
hear the
Union of
matter.
India, respondent number 3 and 5, shall file the
we hear the
respective
matter.
affidavits in the matter on or before 35/25, serving copy of the same on the landed council for the petitioners, failing which the writ petition shall proceed ex parte against the erring respondents.
We then proceed, there's a judicial order, we can't do anything.
May I begin, my lord?
Who has certified the existence of fruit bearing trees?
My lord, it's by the district collector, deputy commissioner, office of the deputy commissioner. But in fact, it is not for the user agency to see whether all the procedures has been followed or not. It is for the acquiring authority, the deputy office of the deputy commissioner, to ensure that the entire process is made free, fair, and transparent in the transparent manner. In this case, totally there was no transparency. The entire process was carried out in almost a surreptitious manner. We are just simple villagers. We were not privy to the entire process.
No, we made a statement to you earlier that I really wanted to visit any place in the state of Arunachal Pradesh where there are cardamom trees as given in this page 24. We wanted to visit and see for ourselves. I have never seen fruit bearing trees like that. So before I demit my office,
My lord,
have
I would suggest your lordship should visit these places, Anjao district.
it's not
And
there.
It's there. I have gone. Kapapu is the now LAC, line of actual control.
You see, do you have an idea of how many quantity of cardamoms are sent from here to outside the state of Arunachal Pradesh? Do you have an idea?
My lord, it is in tons.
Hmm?
In tons.
You have the data.
From Anjao district alone, it will be in tons. My lord, I have slowly found out in 2010 to 11, it was about 655 to 907 tons of large cardamom. 2016 to 17, it was about 3,131 tons. In 2017, 2022 to 23, it is about 1,751. And recent government claim is about 4,467 tons of large cardamom, making the Arunachal Pradesh the leading producer in the entire Northeast.
Well, if you have already measured it, Mr. Ratan, if you have already measured it in accordance with this 24, then you'll have to follow it has to be reassessed. It has to be reassessed. That reassessment was not done in accordance with this page 24.
Yes, page 24, annexure 4, 26. So this is the rate fixed by the government. And then this was followed in package B, my lord. My lord, this road has two package. Package A is 0 to 6.5 kilometer. Package B is 6.5 kilometer to 16 kilometer. First, they took up the package B, and in that in the year 2020, they have submitted a assessment report, and where they have taken the rate as per the approved rate as of paragraph page 26, my lord. 2,000 for the fruit bearing and 1,000 for the non-fruit bearing. Now, my lord, that report had undergone various judicial scrutiny, my lord, in the single bench, division bench, Supreme Court, and then, my lord, as per direction, that amount was paid, disbursed also. Now, my lord, in package A, what they did is they have relied upon one notification issued in 2011, whereas this page 26 is 2015 notification order.
Has to be revisited.
No, my lord, they board on the ground that there is no rate fixed for the district of Anjao, and based on the 2011 notifications, they have fixed at the rate of 900 uniformly, my lord. Whether it is fruit bearing or non-fruit bearing, it is 900. Now that is my only first ground that, my lord, when government has approved the rate, you could not have changed it when that has gone the judicial scrutiny and no adverse finding has been made. Then, my lord, another aspect is that if your lordship comes to page 36 of my petition, this is the total total calculation of the re-verified
page number
35. 36, my lord.
Yes.
My lord, if your lordship comes to this total here, no solitium added, no interest added. Their only ground is that since this acquisition was conducted under the 1947 Jumeland regulation, where there is no provisions of solitium and interest. That is because in any case, even under Land Acquisition Act 1894,
Solation would not be on the fruit bearing fields. It would be on the land.
Land. So solitium is for the total compensation, land and the properties. Land includes all the properties, madam. Under 1894 Act, it was 30% lithium. Under this LARA 2013, it is 100% lithium and 12% interest.
Yes, you're right.
And they have justified their decision by saying that the board had constituted. Now, the board members in their affidavit in affidavit in opposition, paragraph 7, they have submitted that there is no fixed rate for the district of Anjao, and therefore the board, considering the 2011 notification, they have arrived at this rate. But in this board also, there is all the board members are all government officers only. Not a single person from the public has been included. At least any authorities who is representing the public, at least the JPM or the Ansal Samiti or what the Gram Panchayat members, even if Gambura also, had they been included also, there would have been different thing. But then all our government.
That constitution has not been challenged.
Not been challenged. And there is nothing, they have not said anything that this 2015 order has been superseded. Nothing, no records, not even averments. I mean, in fact, in paragraph 3 of their affidavit in opposition, they have admitted, because in paragraph 6, I have categorically stated that these are the notifications, and on this basis only the rate has been fixed. And that averments has been accepted in paragraph 3, saying that the averments therein are a matter of records. So, this is a total direct admission. Your Lordship, kindly come to page 51 also, where the name of the board members are.
Just a moment.
Another thing is, my lord, although they are referring to this 2011 notification, but they have not annexed the copy of the 2000 notification also, 11 notification.
Yes, what do you have to say, Mr. Ratan?
My lord, first of all, my lord, although they have not annexed the notification under which this land has been acquired, we have in our affidavit clearly stated that this land was acquired under the June Land Regulation, my lord, 1947.
You said that issue has been settled by the Supreme Court by now.
Yes, my lord. Now, my lord, I'll just take your lordship. Whatever they have stated, I'll take your lordship. How this present petition came to be filed. My lord will kindly see the prayer portion of the petition at page 15.
Yes.
Direct the Deputy Commissioner Anjao District to revisit the assessment report dated so and so by revising the rate of cardamom per stump and also to calculate and add the 100% solicium and 12% interest over the rectified amount as provided under section so and so under the right to fair compensation and transparency in land acquisition so and so, so and so. Now, they have relied on the orders of the earlier proceedings. Whereby the rate of cardamom has been given at rupees 2,000. Now, my lord, this particular stretch of land also was the left out portion. This is 0.00 kilometer to 6.5 kilometer. Earlier was from 6.5 kilometer to 65 kilometer. Now at page 13.8, my lord, annexure 9, what they have, how this litigation has started, my lord. This is their own representation. Correction of the rate of cardamom at the rate of rupees 2,000 as per so and so, so and so. As affirmed by the Guwahati High Court in WPC number so and so and read appeal number 24 of 2022 and SLP number so and so. Non-calculation of solution and 12% interest as provided under right to fair compensation and transparency in the Land Acquisition Relief and Rehabilitation Act 2023. Now, my lord, here they have narrated the history, my lord. With reference to the calculation of the compensation pertaining to the construction of defense road from Chaglogam to Rocham between 00 kilometer to 6.5 kilometer, we would like to highlight that the following few lines for your kind consideration and necessary action, please. That's initially the verification of the land between 0.00 kilometer to 6.5 kilometer was carried out, and an amount of rupees so and so was assessed. The rate of cardamom was fixed at 2,000. Later on, the said assessed amount was recalculated and reduced to the rate of cardamom from 2,000 to 900. The said decision to reduce the rate of cardamom from so and so 2,000 to 900 was challenged in Guwahati High Court so and so, and the High Court was pleased to quash and set aside the recalculated amount and affirmed the earlier assessment by the cardamom rate was calculated at 2,000. The state AP challenged the single bench order in WA number so and so, which was dismissed on so and so. Thereafter, the state of AP filed SLP number so and so, which was also dismissed on 15/5. My lord will kindly see. The SLP was also dismissed on 15/5/2024. Yes, my lord. It is clear that the rate of cardamom at the rate of rupees 2,000 stands affirmed by the Guwahati High Court and the Supreme Court of India, and hence the same rate at the rate of rupees 2,000 has to be calculated for cardamom in all aspects pertaining to the construction of defense road from Chaklogam to so and so between 0 kilometer to 6.5 kilometer, and accordingly the payment was released. Payment was released at the rate 2,000 per cardamom plant. It is also to be brought to your kind notice that earlier assessment report had missed out our properties, and thereafter a re-verification was carried out, and an amount of 50,21,000 so and so was worked out and forwarded to the BRO so and so. We were not party to the calculation and preparation of the rates, etc. Hence, we were not aware of the rates so fixed. Till this, my lord. Now, my lord, the said rupees 50,21,040,463 was disbursed on 10/1/2023. My lord has seen. This was disbursed on 10/1, meaning thereby they have accepted on 10/1/2023. This representation is made on 13/8/2024. My lord will see page 38 in there. And this representation claim also is first time after the SLP was dismissed on 15/5/2024. After the disbursement and recently we came to know that the rate of cardamom was calculated at 900 and not 2,000. We have requested you and other concerned authorities to correct the rate, but despite assurance, nothing has been done to rectify so and so. The result of the forwarded amount by so and so dated so and so shows that solicium and interest as provided under section 30 of the LADA Act 2013 has not been added. Calculation of solicium and interest is mandatory and denial of the same is arbitrary. Therefore, you are requested to rectify and forward the amount, rectify the forwarded amount of so and so dated by revising the rate of cardamom so and so per stump. My lord, they have received the compensation on 10/1/2023. SLP.
You see, when it's a citizen dealing with the state, will a citizen deal with the state with the knowledge that the state is unscrupulous element and they may play fraud on us? Will that be the way for a citizen to treat the government? So you take over the land, you will have to give a fair compensation.
Yes.
If you don't give a fair compensation, what would it mean?
Yes, my lord.
that there's no difference between a
Yes, my lord.
stateless person and the state government.
Of course, my lord.
State cannot take advantage of
Yes,
its
ma'am.
own fault for
My
not
lord.
giving a compensation.
Yes, my lord. My lord, they are basically aggrieved by the rate of cardamom, my lord. Earlier, 2000, my lord, my just simple submission will be, rate of cardamom cannot be fixed for indefinite period, my lord. There are fluctuations in the rate. And I'm not on this, I'm not
That
on
is the
this
wisdom
aspect
of the,
also.
that is the wisdom of the government.
I'm not
They
on,
thought to have the price at 900 rupees. Nobody questions the government, correct?
yes,
Then you fix it at 2000, nobody questions that. You, what would be the price of cardamom? 1 kg cardamom would be how much?
It's about 1 kg is about average 1200 to 1900
Per kg.
per kg. And in one stump, there will be about it grows lots. So I do not know exactly how much kilo it will. But
A plant normally cannot give a yield of more than it is average between 1 to 2 kg.
1 to 2 kg. Average is around.
And
yes,
average
2 kg.
lifespan is 15 years of a cardamom plant.
I think it's more than that, slightly 15
No, that's an average.
average on.
We don't know about variety or variety B, but an average. So it is 15 years. Therefore, it is the wisdom of the government to fix a rate. From the government, you are not questioning that. Then, can a citizen?
my lord, that's why in our affidavit, we have justified what rate has been fixed. That now, even without going into this aspect, I'm on the maintainability of this writ petition at this stage, my lord. After they have received the compensation, in their own representation, they have narrated the history with regard to the other part of the acquisition, my lord, other part of the road which was acquired, and the rate. They did not. There were litigations going on. They did not question. In between, when the litigation was on, they accepted. They accepted without any protest. They accepted the rate, the compensation. Now, once it was the SLP was this.
Can I give you a horrible example? You see, a council quotes a fee of rupees X. The client says that I have got Y money with me. Please take it. Then we'll settle the fees later on. And the advocate accepts Y rupees. Obviously, there's no memorandum drawn up. Now, will it debar the lawyer from asking the amount of X when ultimately he takes up the brief on the ground that you accepted Y without any protest?
No, that is a different matter altogether, my lord. Here, they have.
Because it affects you.
No, my lord, why I'm coming? This was.
No. You see, I have told you earlier when we started this matter a few moments back. You see, when it comes to state is not expected to give unfair compensation merely because somebody has accepted it. Will not give the right to a state to assert the dues which is actually payable to the person who is losing his land and the zirats thereon.
Yes. That's why I'm not on the reasonability of the compensation, my lord. What I'm not on the, if there's requiring, that's why before the my learned friend started, I was if the requiring the body says that we are ready, then we are ready to pay the compensation whatever claimed by the petitioners. We have nothing to say. But if
so, where are the documents relating to the to the purpose of calculation and then handing it over to them, where is the memorandum drawn up with regard to the calculation? Which-
My lord,
by which basis of-
in our affidavit, my lord will see affidavit at page,
49.
yes, my lord, prior to that, board proceeding is given, my lord, but in their writ petition itself, my lord, before coming to our affidavit, in the writ petition itself, at page 29, Annexure 6. This is 26th October 2020. Hearing is hereby fixed on 3/11/2020 at 10 hours AM for scrutinizing the claims and objection in connection with the construction of defense road from Chaglongam to Rocham between so and so 0 kilometer to 6.5 under Chaglongam circle. Therefore, all the claimants, complainants of land, properties, owners, etc., that is agriculture, horticulture, civil construction, buildings, etc., are hereby requested to appear, attend in the office of the circle officer, Chaglongam, as per the date and time. Then again on page 30, my lord, 14th September 2022. Submission of rectified verification report regarding claims of left out property. Here, reference is of the given, my lord. With reference to the above cited subject, I am forwarding here with the rectified joint verification report of claims and objection as per office order number so and so dated 8 September 2020. This 8 September 2020 pertaining to proposed construction of defense road from Chaglongam to Rocham between so and so under Chaglongam and submitted
Ratha,
by the, yes, ma'am.
What Mr. Bhatin had argued is twofold. Number one, so far as the land which was acquired by virtue of the earlier notification from 0 kilometer to that 6.5 was, for that he is not claiming a dispute. His dispute relates to the leftover land
Yes.
for which there was no acquisition proceedings. And therefore, you could not have called the petitioner for a negotiated settlement for the land, left out land, for which proposal was forwarded to you by page 37, 1st November 2022. So perhaps you are confusing with two things separately. We are dealing with in a single head. Number one, there's no dispute which Mr. Patel is raising on the land for the which is already acquired. So this is the left out land.
Yes.
And in left out land, there was no negotiated settlement for payment of compensation.
No, this, my lord, I've seen, I've shown. This was the.
For this, you made an assessment. The deputy commissioner makes an assessment on page 37. Now the
Assessment has been made after, my lord, at page 30, Annexure 7. This, the verification report. This is the assessment, how.
Page 30.
30. Annexure 7. This was by the additional deputy commissioner to the deputy commissioner.
No, this is letter of 9/7/22. 14 September 22.
Yes.
It
14
relates to
September.
proposed construction of so and so to so and so.
Yes.
So therefore, this is not with regard to the excess land. Come to page 30. Page 3 does not say leftover land.
No, this is 0.00 kilometer to 6.5 kilometer. This is the left out land.
But come to page 37. Here it starts with the left out properties.
That, my lord, that also in the heading subject, my lord, in respect of Chaglongam to Rocham, defense road 0 kilometer 0 to 6.5 kilometer.
So you'll have to show us that this left out properties
Yes, my lord.
is, they are prohibited from making a claim.
Yes, yes. My lord,
Is there any decision of that sort?
my lord will kindly see this, how this calculation was done, how this verification estimate was done, my lord. Public hearing, claims and objections was done. Then re-verification. Page 29 is the first public hearing for claims and objections. Then page 30 is the second re-verification after.
This is a very difficult to accept. You see, can a person who is, let us say my court master, she gets a salary of A. She is duly accepting the salary of A for several years. And then after several years, she finds out that her salary should have been B, and therefore she was wrongly placed, and therefore she's been underdrawing her salary, which should have been calculated at B. Now, will you say that she is prohibited from coming to court
No,
asking for B?
No, my lord.
So therefore, you see, he is calculating certain items, and I have received the money, and therefore after that, he got the notion that these are left out items. These items were destroyed or taken away.
No,
and
no,
for that, I
my
have
lord,
not received a compensation.
not left out. Only the rate. They are not claiming any left out items.
It's your deputy commissioner writing left out property.
This is not, the entire stretch of road was acquired in two phases. One from 6.5 kilometer to 60 kilometer. This is 0.00 kilometer to 6.5 kilometer. That is why the word left out. The earlier acquisition from 6.5 kilometer to 60 kilometer, that was done. This is the left out one.
Okay.
My lord, not the property. They left out stretch of road, my lord. Now, my lord, they have calculated the item at page 31 onwards, item wise, and the beneficiaries who whatsoever they have been done, my lord. They are basically aggrieved by the rate, which is fixed at for large cardamom. Fixed at,
When was this? What is the date of the notification by which the land was acquired?
my lord, this 2020.
2020.
17.
Huh?
17 or 22.
No, this, the requisition was placed by Annexure 1, as page 17, on 27 March 2017 by the BRO. And thereafter,
Just a moment.
under
Just
Annexure
a moment.
2, page 19,
इसको हम ये कर दें.
No, not this. This is not the acquisition. This is only proposal.
it's just
Where is the
they
acquisition of
have
that?
not also followed the, in true sense, those provisions under Land Acquisition Act or 13 Act. They just issue the order. They
Mr.
got the
Ratan,
petition.
Yes, my lord.
the land is acquired sometime in 17, correct?
Yes.
You're not disputing that. 2017 land acquired. Now the compensation according to you was paid when?
23.
23.
Yes.
Where is that?
My lord, in their own
Just shows this
page 39.
page 39 of the writ petition.
Yes, my lord. Their own, in their own representation. Page 39.
Yes.
In the paragraph in the middle, my lord, the set 1, 2, 3, 4, 5, 6, 7, seventh line, my lord, in the middle paragraph in the middle, my lord, the said rupees 50 lakhs 21,000 so and so was disbursed on 10/1/2023. This representation was filed on 13/8/2024, after more than a year.
No,
More than 1.5.
no, something is wrong. Either something is wrong or I'm not being able to follow you.
My lord, they have
The-
received, my,
No. Where was that? uh, This,
the requisition.
no. You see,
So-
that's why I'm saying I'm not being able to follow you. You see, this amount of 50,21,463
Yes,
is also reflected in page 37.
yes,
In page 37, it is in respect of land, left out land of 0.0 to 6.50.
yes.
Now, what you are saying is that the land which was acquired earlier was from 6.00 kilometer?
6.5 to 60 kilometer.
No, 6.00, something, some document says 6.00.
My lord, page 39, my lord, 38.
No, just,
My lord, page 38.
please,
Yes,
just a moment. Because I've read it somewhere. Yes, page 20.
Yes.
6.00 to 16 kilometer, that is the Office of Additional Deputy Commissioner.
yes,
So it is 6.00,
6.00 to 16.
not 6.5,
No, my lord,
correct?
yes.
Now, whether it is 6 or 6.0, we don't know, but this is how where I read it. For this, what was the compensation amount paid?
This compensation amount, it was, my lord will see, 35 crore 94 lakhs.
Where is that amount?
That is
Where do we
total
find that amount?
valuation. At page 21. Yes. Page 21,
21, so 3594.
3594.
You mean reduce?
Yeah,
Lordship, may come to page, paragraph 4, 5, and 6 also, my lord, in merit petition.
It's okay, we're going by what Mr. Rathan is saying.
Yes, my
So
lord.
this is paid. Now, for the additional land, which is, that was in 2023, there 50 lakh odd rupees was the compensation amount, which was paid on 10/1/2023.
Yes,
Correct, now facts are clear.
10/1/2020. My lord,
Yes, then
pay-
there is the complaint on 13/8/24.
13/8/20. My lord will kindly see in there, this page 38 itself, in the starting, means they are claiming from, with reference to calculation of compensation amount pertaining to construction of defense road from Chaklagam to Rocham between 0.00 to 6.1.
Okay.
So we are confined only to this.
Yes.
We forget about the
Yes,
earlier one.
This 35 has been referred only for the purpose of knowing that the rate, at the rate of 2,000 and 1,000 were paid.
okay, then.
Now, in paragraph, in page 39,
Yes,
they have narrated all the litigation earlier with respect to the earlier stretch which
yes,
was acquired.
yes,
My lord will see the state of AP challenged the single bench order in WA number 24 of 2022 and which was dismissed on 4/1/2023.
yes,
Thereafter, the state of AP filed SLP number 48 so and so 2023, which was also dismissed on 15/5/2024. My lord, meaning thereby the litigation with regard to 900 and 2000, the rate that was going on, it was ultimately dismissed. But while the litigation was going on, in between, they have accepted the rate. They have not accepted the rate of 900. They have not gone for any litigation. Only when the SLP was dismissed, then they filed this representation saying that SLP has been now dismissed. We are also entitled to. Now, why I'm saying this, my lord? Because this is afterthought after the SLP was dismissed. Now, we are relying on Mihin Laling's case, my lord. Mihin Laling case also, the honorable single bench has held that although lands are acquired under the Jum land regulation, but compensation, reasonable compensation cannot be less than the rates prescribed under the LARA Act. That principle of law was upheld by the division bench. And the state went up to the Honorable Supreme Court. The Supreme Court also upheld it. In the meantime, of course, the state also amended the Jum land regulation, incorporating that the rates will be as per the LARA Act. Only the procedure for acquisition will be under the Jum land, but the rate compensation will be fixed under the LARA. Now, while the Supreme Court disposed of the Mihin Laling's case, there was a rider given that all those acquisitions where compensation has been calculated, accepted and disbursed, no new reopening of the cases will be done. Here, compensation was accepted, calculated, accepted, disbursed, they have disbursed. And they have agitated for enhancement of compensation only after more than 1.5 years, my lord. 1 and 8 months, 1 year and 8 months, my lord.
Yes.
My lord, in their affidavit in reply at page 65 onwards.
We've seen that Mihin Laling.
Yes, my lord.
Seen that, huh?
If my lord comes to page
Para 28, you've seen that.
Yes. Para 28, what it specifically says, because here it, in this present writ petition also, they are claiming for solicium and interest. Here in para 28, it says, in respect of concluded acquisitions where compensation has been finally determined, accepted and disbursed, no reopening shall be permissible. The impugned judgment of the High Court is therefore set aside to that extent. However, in all matters which remain pending either before the competent authority or before a court tribunal, the compensation shall be computed to include solicium and interest as above. This is there. But in this particular case, as per their own showing, that the compensation was disbursed on 10/1/2023.
In this order of Supreme Court, we don't have that writ petition or writ appeal number of Mihin Laling.
My lord, yes, my lord.
You can provide us with that case number and the date of disposal.
Yes, my lord. That I had I have not printed out, my lord. Otherwise,
Just find out from our system. The name of the party is
Read it
Mihin,
in
M-I-H-I-N. Mihin Laling, L-A-L-I-N-G. We don't have the writ petition number, but the date of disposal of the writ petition is 12/9/2022. 2020.
No, this Mihin Laling case is 16 September 2025. Yes.
No, she has got it. Just find out from our court website. Okay.
Now, my lord, I'm on the aspect of solution and interest and reopening of the concluded acquisition, my lord.
Yes.
Even in Mihin Laling's case, they wanted solution and interest, my lord. But in the Honorable Apex Court has clearly said that where compensation has been finally determined, accepted three
Taken that
ingredients
point.
and disbursed. Now, on that context, whether this Honorable Court will reopen, will make a direction for reassessment.
For that,
of-
we'll have to wait till we use our pen.
Yes, my lord. For that only, that's why I was initially submitting that if the requiring body is ready to pay, we have nothing. But this legal aspect, because once concluded acquisition, once they have accepted, just because the other SLPs have been dismissed, now they come up. Otherwise, even during the pendency of the earlier litigation, had they joined that, we were also been given at this rate of 900, not 2,000. We also are aggrieved. We also want to join the litigation. That could have also been done, but they never choose to participate. They accepted without protest. And then after 1 year and 8 months, they first make their claims, my lord. Now, with regard to this concluded contract, many cases were pending before this honorable court, which ultimately came to be dismissed. One of the judgments is here, my lord. Relying on Mihin Laling's case, my lord.
Yes.
Here also the same thing, that since cases were pending before this honorable court, the Mihin Laling's case will be covered and they have to be paid solution and interest. But this was, even though the matter was pending before this honorable court, since they have already accepted the compensation and it was dispersed, so honorable court declined to entertain their writ petitions. This matter, there are many analogous matters pending before this honorable court during the pendency of Mihin Laling's case. Around 20 matters, my lord. This
Okay.
para 24 is clear, my lord.
Okay. Anything else?
My lord, and this single bench order has been upheld by the division bench also. That just because matter is pending before the honorable court, this will not automatically be the petitioners will not be automatically entitled for solution and interest, because once it is concluded, once accepted, compensation has been determined and accepted, there cannot be any reopening. That has been affirmed. Just because a matter is pending before this honorable court, that itself will not be sufficient.
Well, just one point clarification.
Yes.
Your Lordship, may come to page 75 again. Let us read paragraph
75.
28, my lord. Now, my lord, this main learning case is dated 16 September 2025.
Yes.
Paragraph 28, my lord. In respect of concluded acquisition where compensation has been finally determined, accepted, and disbursed, no reopening shall be permissible. The impugned judgment of the High Court is therefore set aside to that extent. However, my lord, in all matters which remain pending either before the competent authority or before any tribunal, court tribunal, the compensation shall be recomputed to include solitium and interest as above. Now, my lord, here, my lord, the word court in all matters, my lord. However, in all, my lord, can we read this in all matters in a watertight compartment? Will it not include those matters which is pending before any authority? Now, my lord, let us come to page 39 of my writ petitions, my lord. The annexure 9, my representation. My representation is dated 13/8/24. It is before 16 September 2025, before the judgment of the Supreme Court. Now, my lord, I am addressing it to the Deputy Commissioner, Anjao District.
Representation,
Page
is dated,
38, my lord.
dated
13/8/24. Annexure 9, my lord. My lord, I am addressing to the Deputy Commissioner, Anjao District. Now, my lord, who is the Deputy Commissioner? He is the land settlement officer duly authorized by the state government for that district. Now, whether the Deputy Commissioner, isn't he a competent authority? My lord, this representation has not been disposed of. And that is my another case. This is still pending. Also, therefore, paragraph 28, first part of the paragraph 28 will not be applicable to me, but paragraph 28, second part will definitely apply to me, because in all matters, my respectful submissions to my limited understanding is the word in all matters include any representations which has been submitted to the competent authority, my lord. It cannot be just that the compensation has been closed. It is not that case, my lord. So therefore, my lord, my case does not come under the concept of concluded this thing. And in any case, my lord, I have challenged the entire assessment report, because assessment report suffers from illegality because it went on the premise of neglecting the rate fixed by the government. My lord, in any case, my lord, the entire process, right at the beginning, I have submitted my lord. I'll be concluding. The acquisition process must be free, fair, and transparent. Government, state authorities are expected to be very, very fair, take care of the needs of its people, not to deny. And this is a classic case where we have been denied by the respondent authorities. And I seek your lordship's indulgence for protections, my lord.
Okay.
Obliged, lordship.
We're passing orders
My lord.
today only, but it will be uploaded only tomorrow.
All these arguments, my lord, we have done in the single bench and the division bench. First of all, we're already accepted, determined, accepted, and disbursed. Then, if even accepted with protest and pending determination, that would have been But here is a case where already accepted after 1 year, 8 months, they have approached.
Okay. Mr. Patil, you are coming to the chamber?
Yes, I'm coming.
Mr. Ratan, please join him.
Yes, ma'am.
Since he's the respondent, and I'm speaking to him, you'll have to be correct.
My lord, my lord.
And Mr. Raju, you can also come in for a moment.
Mr. Nair also is here.
Just this one.
My lord, judgment reserved.
Yeah, no, it will not be reserved. It will be declared, ordered today, but by the time.
October matter, item number 4.
Well, in this matter, my lord, the principal, the one Anand Tapan, my lord, is online. My lord. He wanted to.
Sir, good morning, sir.
Yes. What is the difficulty in releasing the student?
So there's practically, sir, there's no difficulty, sir. The parents have already been apprised that they are supposed to undertake a certain formality with regard to release of TC, sir. At no point of time we have denied to give away the TCs to the parents, sir. In fact, we
And
have.
what are those? And what are the conditions, sir?
Sir, the conditions as per the Sainik School Society, sir, the MOD condition, it says, sir, that if the parents are withdrawing their child on their own, they have to pay the scholarship which has been availed from the state and the central government in full, sir.
So yes, for the petitioner, what is the difficulty?
Your Lordship, may I take your Lordship to paragraph 17 of the petition, your Lordship, page 19.
Well, just tell us.
Yeah,
You see, we are, the principal is there. We don't want to hold him up.
Yes.
Just tell us what you want to say.
Your Lordship, the problem here is that to procure the transfer certificate now, they're imposing for reimbursement of amount, your Lordship, amounting to around 4 lakh
If you
60,000.
have received the money, then you'll have to give it back.
Your Lordship, now the rules they're relying, your Lordship. Here, the rule says, your Lordship, where the wards or guardian, they
No, then we'll hear
voluntarily.
it. We don't want to detain the principal who is online. We just wanted to have, he has no objection, but that is the requirement of the society to reimburse the scholarship already availed. If that be so, we have no requirement of the principal to be here. Are you online?
Yes,
He's
sir,
been
yes, sir.
disconnected.
No, he's
No, no,
there.
sir,
Okay,
I'm very much
then-
online, sir.
Okay, then you may disconnect because we don't want your requirement. Then
Sir.
whatever is happening, we'll take care of in the writ petition. Your CGC is there. We
Right,
thought
sir.
that there was some impediment which is being created by you. But once you say that
No, no,
it's
sir,
the
sir, not at all,
reimbursement
sir,
of
on-
scholarship, okay.
Sir. So on the contrary,
Okay,
sir,
then-
just to inform the lordship, sir, as a special case, sir, in order to help the parents and the cadets, sir, we have taken up a case with the LBA, sir. Though it was not supposed to be disclosed, but I am disclosing it in front of you, sir. 20 days back, we've already written it to the society. We are awaiting a decision on this, sir.
Okay, thank you. We thought that this impediment, artificial impediment created by you. That's why we required your presence. Your presence is not required. Thank you for
Thank you very
joining.
much, sir. Thank you, sir. Jain, sir. Jain.
Jai.
May I please, your Lordship.
Yes.
Your Lordship, at page 128, annexation number 10, your Lordship.
So then we issue a notice.
Your Lordship, now, your Lordship, the problem is that since admission, your Lordship, is going on, your Lordship.
No, but we can't help it if that
others.
is the requirement. You can
And
give it
now
under
this
protest
rule-
and then withdraw that later on.
Your Lordship, may kindly grant me 5 minutes, your Lordship.
How much time you need?
5 minutes, your Lordship. I'll
5
satisfy
days.
this court, your Lordship.
You pay that money under protest, and if the pending decision by the authorities, if they allow your claim, then you can take it back.
Because even the rules, your lordship,
No, that's okay. You see, you heard the principle. Now, supposing we give you a very horrible example. There are 5 Sainik schools in ABCD, E. You take admission in one, get the scholarship, withdraw it, and go to school 2, take scholarship again, then go to school 3. That can also be a proposition. So in 5 schools, in the guise of taking an admission, you collect 25 lakh rupees. You can't be allowed to walk away with that. The scholarship was to complete these studies.
yes, your lordship, but here the wards are not voluntarily leaving the school, your lordship. They are being compelled. It is the school authority, your lordship, who is not taking admission to the prisoners. This rule will be applied, your lordship, only when the wards or the guardian voluntarily exit from the school, your lordship. That I'm trying to explain before your lordship. There is at page 128. May I read out, your lordship? Your lordship, kindly grant me 5 minutes, your lordship. I'll satisfy this court.
Yes.
May I read out, your lordship? Page 128, last paragraph. For the time being,
The student was rusticated.
yes, your lordship.
Correct. So, for whatever reasons, and then it so as per these incidents, someone had died under mysterious circumstances, and then there were police FIRs, and then the police had investigated the matter, and there were charge sheets submitted against 6 people. Correct.
Yes, Lord.
For some reason, the school authorities thought that you would also be required to be rusticated for the reasons which they have stated. But everything arises out of some incident which happened in the school. We don't want to speak here.
Your lordship, in this case, your lordship, the petitioners are minors, your lordship. So there are certain, your lordship, since, and even the impugned rustication order, your lordship, that has been issued without giving any opportunity of being heard, in violation of natural justice. Now,
hear that.
For this, your lordship,
We'll hear
may I
that.
take your lordship to Section 3 of Juvenile Justice Care and Protection Act 2015, your lordship.
Just give that. Juvenile justice. Oh, you have it here. Okay, it's available.
Section 3, subsection 1, clause 4, your lordship.
Yes.
General principles of care and protection of children. Clause 4, principle of best interest. All decisions regarding the child shall be based on primary consideration that they are in the best interest of the child and to help the child to develop full potential, your lordship. And clause 6, your lordship. Principle of natural justice. Basic procedural standards of fairness shall be adhered to, including the right to a fair hearing. This rule against bias and the right to review by all persons or bodies acting in a judicial capacity under this act. And subclause 3, your lordship, of clause 6. Every child has a right to be heard and to participate in all processes and decisions affecting his interest, and the child's views are to be.
In this case, whether this Juvenile Justice Care and Protection of Children Act will apply.
Your lordship, this act may be not automatically applied, your lordship,
Therefore,
but since the petitioners are minors
person who is
and their children, juvenile, your lordship.
He is neither a person who is in need of care and protection, neither he is a child in conflict with law.
Yes, your lordship.
So
now, this act, special law, your lordship.
we understand, but under the circumstances when the school thinks that you have to be rusticated. Now, who will be heard? A child can't be heard on the issue of rustication. It will be the parents who will be heard.
Yes, your
How
lordship.
can you tell us that? How can you assure us that the child, in his best interest, would be entitled to a hearing. If you can show that, we are issuing a notice, we'll hear you. But in the meantime, you want to take a certificate, you return that money and then take it. Other issues will be open to hearing.
Now, Your Lordship, the problem is, Your Lordship, since the amount is 4,60,000 euro, almost 5 lakhs. Some parents
But
are
you have to
farmers,
bill
Your
that
Lordship.
money.
And one more condition is there, Your Lordship.
Yes.
Apart from giving that money, Your Lordship, the child has to produce physically unfit certificate, Your Lordship, not physically fit. Now, the problem is when the petitioners are physically fit, Your Lordship, in the medical examination, the certificate, Your Lordship, it's physically fit.
Where is that clause?
Your Lordship, that Your Lordship, that condition has been imposed by
Where
the
is that
school
clause?
respondent, Your Lordship.
Show us that.
That is not given here, Your Lordship. But when the parents approach the concerned authority, the school respondent, Your Lordship, they are asking for physically unfit certificate, Your Lordship. And
where is the statement made in the writ petition?
Paragraph 18, Your Lordship, page 20. There were total 11 CCLS. And out of 11 CCLS, Your Lordship, 2 wards has already been issued their transfer certificates. Just because they could produce, Your Lordship, the physically unfit certificate, certifying them that they are physically unfit. Now, rest of the petitioners, Your Lordship, they could not produce the certificates certifying them that they are physically unfit. There is also a problem here, Your Lordship, that I have mentioned in the petition. May I read out, Your Lordship? Out of the total 11 CCLS minor wards, 2 wards have already been issued transfer certificates along with their original documents solely because they were able to produce physically unfit certificates, declaring them to unfit to discontinue in the Sainik school. And at the same time, the present petitioner wards being medically examined and found physically fit, they could not produce such medically unfit certificates, and consequently, the respondent authorities have.
Kathol, this can be relaxed. This condition can be relaxed.
My lord.
Physically unfit, if a boy is not unfit,
Yes, madam.
why will he give a certificate that is unfit?
So
it'll affect his career.
Madam, to some extent.
You're not rusticating him because of his fitness or unfitness.
Yes, madam.
Because of that incident which happened in the school.
Malad, therefore, Malad, my submission would be, Malad, this is not a Malad, the rustication simpliciter, Malad. It imposes, Malad, several other things, Malad. Now, they specifically observe one thing, Malad. If this honorable court, the issues directions, Malad, they are ready, Malad. That way, Malad, they are also, Malad, indicating.
Other issues are kept pending. We are not disposing of the writ petition.
Your Lordship, my only humble prayer before this honorable court is, Your Lordship, I am ready to comply with the rustication order. The only, Your Lordship, my humble prayer before this honorable court is at least the transfer certificate along with all other original documents that has been kept under the custody of the school respondent, Your Lordship. That may be issued, Your Lordship.
Will be
by waiving the, Your Lordship, the reimbursement for amount.
No.
Because those who can produce physical unfit certificate.
That you pay under protest, that will be considered because you are depositing that in the orders of the court. We'll take care of it when we decide the matter. But once you have availed that scholarship, that
Your Lordship, I beg to submit that this rules, this particular paragraph, Your Lordship, this does not apply to the petitioners here.
If not, you will get it back.
At least, Your Lordship, in that case, interim may be granted, Your Lordship.
What interim?
That, Your Lordship, because if any relief is not granted in this case.
The money part we are not relaxing. If availed it, you will have to deposit. We'll direct it to be accepted under protest and then subject to outcome of the repetition or further orders that may be passed, that scholarship money would be taken care of. But right now, we are not inclined. Heard Mr. D. Tatak, learned counsel for the petitioner. Also heard Mr. M. Katul on a DHA for the respondents.
All respondents, all the respondents.
Petitioners S. Huh? Next paragraph. The case of the petitioners that they are minor cadets studying in Sainik School, Niglok, NIGLOK, East Siang districts. Full stop. It is projected that their parents, the petitioners are parents of cadets studying in Sainik School, Niglok, East Siang district. Full stop. It is projected that their respective wards have successfully passed class 10 examinations and are awaiting admission and continuation of their studies in class 11 of the said school for the ensuing academic session 2026-27. Full stop. In view of certain incidents that had happened in the school, the authorities of the said school by issuing separate notices to the petitioners, intimated them of disciplinary measures being taken against the respective cadets pending judicial outcome. And thereby intimating them about the decision of the school authorities for imposing rustication, RUSTICATI1 of their wards as an administrative and disciplinary measure. Next paragraph, it may be stated that as the wards of the petitioners are minors, comma, no reference is being made to the names of the wards or to the incident which led to imposition of rustication. Next paragraph. For the purpose of this order, it was suffice to mention that the petitioners had applied for issuance of transfer certificates in respect of their wards, respective wards, so as to have them admitted in other schools. First off, it is projected that the school authorities have refused to issue transfer certificates along with other original documents, amongst others, on the ground that the petitioners would have to reimburse the scholarship public financial benefit of rupees 4,69,675 received by the petitioners and oblique or their respective wards during their course of studies. The second reason projected by the petitioners is that they would be their respective wards would have to produce not medically fit certificate, inverted commas, not medically fit, and obligor medically unfit certificates. Which would, first of the set two conditions, according to the Learned Counsel of the petitioners, is imposing of restrictive conditions on their respective wards to get education and their school of choice, as the concerned school has issued rustication orders. Next, the Learned Counsel for the petitioner, as a measure of interim relief, seeks directions from the interim directions of the court for issuance of transfer certificates by waiver of the requirement to provide to refund the scholarship referred above, and also from submitting unfit certificate medical certificate. Next paragraph. In view of the issue involved, at the request of the court, what was his designation and
My lord, Colonel
Colonel?
Anand Tapan.
Just write it down
My lord,
and give it so that we don't make a mistake in spelling. And what is his designation?
Colonel.
No,
Principal.
his principal.
Principal.
Principal of the concerned school had
Sainik School, Niglok.
appeared through video conferencing mode and had submitted that the requirement of refund of scholarship is that because the wards of the petitioners are already availed the said scholarships. First of all, he has submitted that there is no other impediment for the grant of transfer certificates. Next paragraph. In view of the issue involved in the rate petition, issue notice returnable on so and so, as the learned DSGI accepts notice on behalf of all the respondents, requisite extra copies of the rate petition, with enclosures be served on him within 2 days. Next paragraph. As an interim measure, the court is inclined to provide as follows. Number one, the petitioners shall deposit before the concerned school authorities sum of rupees 4,69,675 stated to have been received by the petitioners oblique their wards, respective wards, towards scholarships of the financial benefit during their course of studies. Full stop. Within 3 working days of the deposit of the said sum, comma, the respondent number 2 shall do the needful for issuance of transfer certificate in respect of the in respect of the respective wards of the petitioners, comma, without insisting on submission of medically unfit certificate. Next para, the respondent number 2 shall treat the deposit of a sum of rupees 4,69,675 as an amount deposited in view of the orders of the court, and therefore the said deposit shall be subject to further orders that may be passed in this writ petition. Next para, the petitioner shall produce a certified copy of the order before the respondent number 2 for doing the needful. Next para, list on so and so.
May it please your lordship. Your lordship, my humble prayer, your lordship, regarding the payment, your lordship, as your lordship says, within 3 days. Your lordship,
No. I have said whenever you deposit, within 3 days, they will give you this transfer certificate. You may take 1 month to do it. You're not saying anything. But the fact is that whenever you do it, you submit within 3 working days, because schools may have holidays. We don't know when you deposit. Next, how many days would be not a working day for the school. So whenever you deposit 3 working days, they will give you the certificate.
your lordship, the 2 CCLS, your lordship, who have already obtained the certificates, your lordship.
Pardon me?
The 2 CCLS, your lordship, who have already received their transfer certificates. Your lordship, since they could produce medically unfit certificates, your lordship. So your lordship, they have already been waived, your lordship, for the repayment. So that will be your lordship. That will be considered, your lordship. I again
I
take
don't
this.
get it. Please repeat again. I did not get it.
The 2 wards, your lordship, who have already obtained the transfer certificates. To them, the transfer certificate was issued, your lordship, just because they could produce the medically unfit certificate, and they have not paid any, your lordship, the reimbursement amount.
Your choice.
Since
You can take
they could produce your
instructions and tell us, because you see, 2 things don't go together. If they have a policy that for unfit people, they are refunding they are refunding that amount, or not insisting that on that amount, then you'll have to comply with that.
Your lordship, that is there, your lordship, even as I've already submitted, your lordship. But my humble prayer, your lordship, again, your lordship, only if this honorable court can waive the reimbursement amount, your
Waiver
lordship,
is
because
subject to outcome of the order. We can't allow your writ petition at the motion stage. If we pass that order, then what remains to be adjudicated? In an interim order, we can't allow the writ petition. That's a well settled law. Even I have passed such orders. So you have to show us. You see, please try to understand. It's only because you are appearing for the young children I'm interacting with you.
yes, Lord.
Not otherwise. For others, I would not have interacted. It's not my duty to explain it to you.
Your lordship.
Since you are appearing for students, I'm just telling you, you see, there are 2 things you are wanting. Number 1, waiver. then you say that the waiver to others were done because of the fact that they could produce unfit certificate. So can we ask the authorities to treat you and the others differently? If it will be a rule of law which will prevail, then you will have the same standard. You also produce the same unfit certificate and get it. But if you are fit and they have given you the disbursement of the scholarships, then how can we prevent the state from recovering it? You would be depriving somebody else of that scholarship. You know the reason. A school will have, let us say, the school will have 30 seats. For 30 seats, they got money from the government of India, gave it to 30 students. Now 2 students have gone out. What happens to 2 people who are now coming in? If there's no policy of the government to make reimbursement. So if somebody gets rebate because of the fact that it is unfit, it is covered by a policy. So you take your choice. You can think over, have some cool air and come back because I'll be signing not before 4 o'clock. So if by then you have a change of mind, please tell us. We can still modify the orders. Okay. Liston so and so. Had it not been that reason, we would not have called for this, given the harsh conditions, and then direct, and Mr. Kato would have not produced asked the appearance of the principal. They took it very seriously.
Item number 12.
Yes, may it please your lordship. Lordship, in this matter, we had been on the closure of the DRDA agencies in Arunachal Pradesh. The employees of DRDA were absorbed in the Rural Development Department. We were absorbed as APO, that is Assistant Project Officer, Rural Engineering, Rural Development. But later, another notification came up wherein we have been shown to be absorbed as technicalists. So that is why we are before lordships. If lordship initially comes to the post creation, the sanction, my lord, at page 47, if my lord comes to, while I'm bothering lordship with the post creation for one reason, my lord, page 47 is the creation of post. Serial number 3 at page 47. This is number of posts 2. My lord finds page 47.
Page 47.
Page 47. This is an order dated 29 July 2002. My lord, serial number 3.
Yes.
My lord, there is a creation of 2 posts of
yes. Assistant Project Engineer.
Assistant Project Officer.
Officer 3. RE.
Serial number 3. There are number of posts 2. Then lordship may come to page 54. I'm directly taking lordship to the relevant pages for the post sanction.
Page number?
Page 54, my lord. Only for the column heading. The folded page, my lord.
Yes.
Page 54. My lord, we see the column heading at just before number 5. Column heading number 5. Just above it, my lord will find number of additional posts now created, sanctioned as per the new staffing pattern.
Yes.
My lord, may turn to the next page.
Yes.
Serial number 5 is nil. Initially, serial number 4, there were 15 posts. So 15 posts and 2 posts, that is 17 posts. Now, my lord may come to page 61.
This is of which date?
This is, my lord, 8 February 2007.
No, the page 54 you are showing.
Oh, my lord, I'm so sorry, my lord. I'm
It's
so sorry.
11,
Yes, I'm so sorry, my lord. 11 November 2003. I'm so sorry, my lord.
No, it's okay. Page 47
At
is.
page 51, page
No,
47,
is 2002.
2002. Then page 51 is 11 November 2003.
But in this 11/11/2003,
Yes, my lord.
this two post, has it been added?
No, my lord.
No.
No, my.
Okay, so till now in this chart, it is 15.
15, my lord.
Okay.
My lord, and thereafter, my lord, at page 61,
yes,
page 61, my lord, this is 8/2/2007. One post had been added, my lord, at serial number 4, my lord.
Serial number 4.
4.
Post is 1.
1. One post.
Yes.
So total from these documents, total 18 posts.
Yes.
This is the total sanction post. Now, if I could bother Lordship with again turning back to page 34. This is an office memorandum of 2003. It starts at page 31, dated 20th May 2003.
Yes.
This deals with the personnel policies for recruitment and engagement of staff for administration of DRDS. This Lordship will find in the subject heading at page 31. Now, Lordship may come to page 34, the relevant portion. Wage employment wing. 1, the post of assistant project officer rural engineering in the pay scale of 8,000 to 13,500 shall be manned by taking deputationists from the cadre of extension officer rural engineering of rural development department having minimum service of 11 years in their grade of 4,500 to 7,500 or 8 years in the grade of 5,500 to 9,000 or 5 years in the grade of 6,500 to 10,500 or failing above, direct recruitment may be done on contract basis with consolidated salary. Candidates shall possess minimum qualification of degree in civil engineering. Then, my lord, number 2.
Yes.
Number 2, my lord, the posts of technical assistant IWDP in the pay scale of 6,500 to 10,500 and technical assistant RE will be managed by deputationists drawn from the cadre of extension officer of rural development department having minimum of 5 years service in their grade. Failing above, direct recruitment may be resorted to on contract basis with consolidated salary. The candidates shall possess degree in civil engineering. From here, my lord, extension officer is the feeder cadre for taking persons on deputation to the DRDA, my lord, for both technical assistant IWDP and technical assistant RE. As well as, my lord, this technical assistant IWDP and RE are of the same status. This they have also admitted in their documents later. So assistant project officer is above both these, my lord, technical assistant as well as extension officer RE.
How do you say so?
My lord, assistant project officer shall be filled up by extension officer rural engineering who have 11 years in 4,500 to 7,000 or 8 years in 5,500 to 9,000 or 5 years in 6,500 to 10,500. Number 2, it says technical assistant IWDP and RE, they shall be manned by deputationists drawn from the cadre of extension officer. So the pay scale, my lord, given is 6,500 to 10,500. So to fill up the post of assistant project officer, if an extension officer is there, he has to have 5 years in the grade of 6,500 to 10,500. And if he is to be drawn as an technical assistant, then he has to be in the cadre of extension officer RE. So, my lord, both these posts they are similarly situated. And a person having more years of service in a lesser scale, they can also be considered for assistant project officer if he puts in a longer years of service. So the feeder cadre are different, but my lord, the status of a technical assistant is above that of extension officer, because the pay scale, my lord, is higher. Oh, my lord, we had been appointed, my lord, the petitioners, we had been appointed, my lord, from Annexure 3 series, we have given the appointment orders, my lord. At para 6, I have stated so because of one petitioner, I do not have the document, my lord. Para 6, my lord, we were initially employed on contractual or temporary basis. We were, petitioner 1 was regularized in 2007. Petitioner 2 and 3, my lord, in 11/5/2007 and 2/11/2008, respectively. This I have stated in paragraph 6, my lord, of the petition. Now, while we were serving as technical assistant IWDP, my lord, we were aggrieved that technical assistant rural engineering, they were being considered for promotion to APO, but we were not being considered. Therefore, we had approached lordships by way of a previous writ petition, and we had given representations, my lord. These representations, my lord, they were, lordship had disposed of, and that order I do not have, my lord. This was of a previous one. But if lordship comes to page 75, this is the photocopy. Page 76 is the typed copy. It says disposal of representation in terms of the direction of the Honorable High Court, Naharlagun, WPC so-and-so, dated 14/4/2016. It is in receipt of the above mentioned representation along with the Honorable High Court's order dated 14/7/2016, whereby it was directed to dispose of the representation. The matter has been examined and found that the posts of TA-RE and TA-IWDP under DRDA autonomous body are of the same status, and their qualification for recruitment is also same. The recruitment rules for the post have not been framed, and therefore vacancies in the grade have been filled up on temporary basis. If any vacancy in the grade of APO-RE occurs in future, possibility shall be explored for accommodation from the grade of TA-IWDP and TA-RE. So, my lord, from here, what we find is that there is no recruitment rule for filling up posts of APO-RE. In fact, all the APO-REs, they were deputationists. There was no promotion to the post of APO-RE. They had been exercising functions as deputationists and on in-charge basis. We were also given to hold charge of APO-RE. Now, my lord, our orders allowing us to hold charge, my lord, they are from Annexure 5 series from page 77. From page 77 to page 83. These are all the orders from March 2021 onwards, 11th March 2021, 27.
You're saying that page 87 order.
My lord.
Correct. 87 is the, what do you call that?
87 is the initial notification. I'm not aggrieved by this, my lord. I'm aggrieved by page 102. Yes, my lord.
102, 1st May 2025.
Yes, my lord. Whereby we have been demoted to the grade of technical assistant.
You are presently the
page 104, my lord. We are again reverted to TA-IWDP.
TA-IWDP.
IWDP, my lord. Initially, we have been absorbed as APO because we were discharging functions of APO-RE, though on in-charge basis, my lord. And on closure of the DRDAs, my lord, page 87 is the initial order. 22nd February 2024, my lord. Whereby the relevant ones, my lord, at page 89.
But technically speaking, come to page 34.
My lord.
Post of assistant project officer.
My lord.
Shall be manned by taking deputation from the cadre of extension officer.
My lord.
Having minimum 11 years in the grade.
Yes, my lord.
of so-and-so or
My-
8 years in that grade.
My lord,
So if they are,
they are all
first
deputation list.
part, it is 11
Yes.
years.
11 years,
And the, if it's in the second part, it is 8 years.
8 years, and 5
And
years.
You were 5 years.
I was, my lord, direct recruitment. I was technical assistant, my
A
lord.
technical assistant.
Yes.
So IWP would be 5 years.
5 years.
So if in page 34.4.1,
My lord,
if somebody is 8 years in the grade,
my lord,
5 years in the grade of 6500,
my lord,
and you are also in the same grade of 6500,
my lord.
then what is wrong in placing you below them?
My lord, the reason being, they were all deputationists. When they are reverted back to the same department, they will go back in their own grade, my lord. They are deputationists. There was a previous writ petition filed. I have annexed that order, my lord. They have to be treated as deputationists. I am not aggrieved by their absorption as APORE. I'm not aggrieved by that. What I am aggrieved by, my lord, is demoting me after absorption as APORE to the grade of TA. All of them were holding charge of APO, my lord. Our orders allowing us to hold charge as APO are there, my lord, Annexure 5 series. They are there. We were holding charge. Then, my lord, page 87, which Lordship has pointed out, that was the order when the DRDAs were closed and we were directed to be absorbed as APORE in the Rural Development Department. Before that, if my lord comes to, if I may.
No, because you see that difference they take in paragraph 7 and 8 is to the effect that there was an inadvertence reflection of assistant project engineer instead of their actual designation of technical assistant.
My lord.
And therefore they say that due to these omissions,
My lord.
on verification, the committee prepared a list of 565.
Yes, my lord.
And then accordingly, the seniority was rearranged.
My lord. My lord, that is why initially I had bothered Lordship with a post sanction. Those were the number of posts. But by this revised order of at page 104 or starting from page 102, there are only 10 posts of APORE who have been absorbed now, though the number of sanctioned posts is much higher.
But there are judicial pronouncements showing that although there may be a sanction post, but to fill up.
Yes, my lord.
Is
because we were not
filled up.
My lord.
It is the wisdom of the appointing authority. They may not want to fill up the post.
My lord. They may not, my lord, but our grievances were we were not being promoted. We approached lordships as well as the authorities. Authorities said on future vacancies, we will consider you. And they allowed us to hold charge, which is rampant here, my lord, in the state of Arunachal Pradesh. There's the concept of officiating promotion. They don't give the promotion, but officiating promotion. Here we were allowed to hold charge. And while holding charge, we were absorbed. My lord, that there was no regular promotion that is reflected from their orders itself. We have obtained under RTI, my lord. If my lord, it comes to my lord, page 124. This we had sought for under RTI, my lord, the petitioners, and they have given a RTI reply. My lord, the total strength of APO they have placed and they have not given. Then serial number B, there is no provision for regular appointment to the post of APORE. Then D, EORE are eligible for deputation to the post of APORE, White Government OM dated 98, copy enclosed. This one was of 2003. My lord, E, there is no regular promotion has been made to the post of APORE. Now, my lord, we have pointed out one case there, my lord, of one Konya Dada at page 116. This they have said under RTI, but if my lord comes to page 116, I'm bothering lordship with going back and forth, my lord, just because of page 116, my lord. This is of 16th October 2015. I am directed to convey the approval of the government for appointment of Konya Dada, TARE, DRDA SEPA as Assistant Project Officer RE in DRDA SEPA on temporary basis plus other allowances. Now, this person, he has in effect been promoted, though they say appointment, he has been promoted from TARE, we are TAIWDP, he has been promoted from TARE to that of Assistant Project Officer. Though it says appointment, because there is no provision for appointment, because there are no recruitment rules. In fact, that is one of our prayers, my lord, framing of recruitment rules. This person, my lord, if my lord comes to the Gazette notifications, once again, my lord, the page 87 onwards, the relevant one is at page 89, the initial, my lord, absorption.
Just a moment.
My lord.
But you see that the respondents have already answered.
My lord.
They said that originally that was done, but subsequently by notification of 22-2,
my lord,
the same was corrected.
Yes, my lord. They say it has been corrected. But this correction, my lord, is after absorption. There was a reason, my lord. There is another writ appeal pending. My lord, because one of the petitioners, Mr. Toli Gamlin, he was posted as APORE, then another person was also appointed as APO in the same district. But we had challenged that transfer order. There was an inquiry wherein, my lord, the other person was accommodated and I was reverted. Thereafter, this notification of the revised notification came into existence, though that person was also not eligible. That is the genesis, though I have not stated so in this writ petition, my lord. The other writ appeal is pending. That's the writ appeal number 237 of 2025.
No, but if the state says that they have already been, because the notifications were corrected,
my lord,
and subsequently they all had become TA,
My-
IWMP.
My lord.
Is it subject to any directions of the Red Court?
My lord, the reason here would be, once they are absorbed, if they are now, again, though they use the term, this notification is corrected, that would imply it is a demotion, my lord. Because they are absorbed, the original department is not there. We were not given any hearing. We were not given any show cause as to why we should be absorbed as TA or as APO. We had been absorbed. The original department is not there. After absorption, we have nowhere else to go.
No, but
My lord.
if it's a mistake, then the mistakes can always be rectified.
But it is actually not a mistake, my lord. Because we were holding charge of APO, we had been absorbed as APO. And the other persons, my lord, they are also holding charge. They are all deputationists. This has been held by lordships in the other writ petition, which I have annexed, my lord, from page 125. In fact, the petitioners there are in this list, my lord, who have been absorbed as APORE. Page 125 to 131, my lord. If lordship takes this page 125 along with page 124, just for my sake, my lord, we can have an idea, my lord. Page 125, the petitioner's names, my lord. WPC 105, the petitioner's name is Hura Kaku. Then down below, my lord, is Kili Bui. Next page, WPC 108, my lord, is Konyo Dada. Thereafter, 119 is Thomas Tasso Bath. WPC 120 is Enes Kushwaha, Yongshe Baka. My lord, now if lordship takes up page 104 together, my lord, Hura Kaku, the petitioner in 105, he's at serial number 62.
Page number?
Page 104, my lord, of the revised list. If lordship sees serial number 62, APORE, it's Hura Kaku. He's the petitioner in WPC 105. Then serial number 63 is Kili Bui. He's the petitioner in WPC 106.
62 then?
62, 63. But before that also, my lord, I'm going by the petitioner numbers, my lord, in the writ petition. 62, 63, then 58 and 59 of this page, my lord, is TT Bath and Dongche Baka. 58 and 59 as well. I'm going by the serial numbers of the writ petitions. And my lord, page 560, sorry, my lord, page 115, serial number 560 is serial 560, my lord, the table towards the bottom of the page. Is Konyo Dada. His appointment order, or rather the promotion order, lordship has just read, my lord. They are all the petitioners.
Yes.
Now, my lord, may come to page 129. The judgment in those writ petitions, my lord. 129, the judgment in the writ petition. Paragraph 2, my lord. These writ petitions have been filed challenging the impugned order dated 19/2/2016 issued by the Commissioner RD and PR, Government of Arunachal Pradesh, wide number so and so, by which order the appointment of the writ petitioners as Assistant Project Officer in the establishment of District Rural Development Agency, DRDA, and posted at such and such places, respectively, have been cancelled and further repatriated to their posts of Extension Officer RE in the Department of Rural Development with immediate effect. Therefore, said impugned order dated so and so has been stated to be issued on the basis of Office Memorandum so and so dated 10/2/2016 issued by the Governor of Arunachal Pradesh, whereby all officiating, functional, appointment and promotion made without having due regard to seniority position of the officials were directed to be reverted back. So from this, we find, my lord, that all of them are deputationists. They were holding officiating posts and they've continued as such. They were sought to be reverted back. They approached lordships and lordships had interfered. Lordship may turn to the next page, my lord. Paragraph 5. On perusal of the Office Memorandum dated 10/2/2016 issued by the Governor of Arunachal Pradesh, it is noticed that the object of the Office Memorandum was to prevent out-of-turn promotion to officials on officiating functional basis in disregard to seniority position of the officials. As such, in order to prevent out-of-turn promotion on officiating functional basis in utter disregard to seniority position of the officials, which was in rampant practice, the Office Memorandum dated 10/2/2016 came to be issued in order to rectify and correct such out-of-turn officiating functional promotion made in the departments. However, the Office Memorandum dated 10/2/2016 has not indicated in any manner as to how officials sent or appointed on deputation basis has to be dealt with. In view of this matter, the impugned order dated 19/2016, by which the order of the petitioners have been repatriated to the post of Extension Officer RE, who were otherwise working as assistant project officers on deputation basis, could not have been issued on the basis of the Office Memorandum dated 10/2/2016. Accordingly, impugned order dated 19/2/2016 issued by the Commissioner so and so, insofar as the petitioners are concerned, is hereby set aside and quashed, leaving it open to the respondent authorities to deal with the petitioners in the manner provided under the rules, insofar as deputationists are concerned. So, my lord, if they are to be absorbed on closure of, they are on deputation to the department. On closure of the department, they have to revert back to the original parent department. When they are reverted, as per the orders of lordships, they have to revert back to their original posts. But that has not been done. Though I am not aggrieved by that. I have not made them parties. I am not aggrieved by that. What I am aggrieved by, what I would like to implore lordships is, all the posts of APORE, they are not regularly filled up. They are held on the basis of officiating promotions. We similarly, the petitioners are also on officiating promotion. Now, to discriminate between these two sets, my lord, who were originally from the department, Rural Development Department, on reverting back, they have to go back as extension officers. They have been retained as assistant project officer, while we, though we were similarly situated, we have been sought to be corrected to be absorbed as TA. That is our grievance before lordships. That is the discrimination which they have done, my lord.
Yes.
My lord. Yes, your part.
May I, my lord? My lord, may I please come to our affidavit, my lord, of respond number 2 and 3. Page 148. Para 6, my lord. May I read? This is our case, my lord. The statement so and so. In paragraph 9 of the writ petition are admitted to the extent that the petitioners were allowed to hold a charge of APORE in their own grade and pay scale for a limited period. On such arrangement was extended from time to time, purely as a stopgap measures. It is submitted that the said temporary arrangement did not amount to promotion to the post of APORE.
But then why do you discriminate? You must have some policy to, some reason to give that notification and then say that they will be placed below.
My lord, their appointment order also, my lord, page 78, my lord, of the writ petition. They were only allowed to look after the charge, my lord, as an a priori. Page 78, my lord.
That is
Page
what is being
78.
followed in the state of Arunachal Pradesh. Everybody is holding charge. How many officers you have holding substantive posts?
But technically speaking, my lord, this case comes on the res judicata, my lord. Writ petition, my lord, this writ petition comes on the res judicata, my lord. May I, my lord? Though in the transfer, in somewhat relevant, my lord, in one transfer posting case, my lord. This was considered. In respect to petition number 3, my lord. In respect to petition number 3, this court has already, my lord.
Made any such statement in your
No.
affidavit?
Yes, my lord.
No.
They must have missed, my lord.
You have to put them to notice. Res judicata can't be argued like
They
that.
knows, my lord. They are on appeal, my lord. Before this honorable court only. There is a writ appeal
No,
pending,
but
my lord.
you see, he may be in appeal, but
Yes.
if you are raising that point of res judicata, you'll have to put them to notice.
My lord.
This is not how issue of res judicata would be taken up. You must have adequate opportunity to rebut that.
My lord.
Yes, yeah, what do you have to, what
My lord,
what do you have
page
to say?
12, my lord. Of the judgment, my lord. This is the petition number 3, my lord.
Page
This-
12.
Page 12, my lord, yes. Of the judgment, my lord. Para 20, my lord.
Paragraph 21, the reason is there, why they are always given charge.
May I, my lord? Para 21. Perusal of the above clarification indicates that there was an inadvertent error with regard to the petitioner's designation as APRE, and there is no record available indicating the government's approval for his appointment or promotion to the post of APRE, and thus has clarified that the petitioner is technical assistant
So
and a
therefore
private
the-
husband.
Therefore, the technical things also the MLA knows whom to be given, who is the person to be given charge.
But here, my lord, there is no such thing, my lord. In this state petition, my lord.
That is why I told you that you have
This one is transfer posting, my lord.
vested interest in keeping people on charge.
That I cannot say, my lord.
It appears, that's why we said, even without reading this para 21, we said that.
That is in respect to transfer posting, my lord. But the issue somewhat was decided, my lord. The issue raised in this writ petition has been decided, my lord. By applying order 1 rule 8, my lord, I'm saying, my lord, res judicata applies in this case. Because this is a joint petition, my lord, joint writ petition, my lord. After para 20, my lord, may come to para 22, my lord.
You see this para 22.
Yes,
although
madam.
this court has accepted it,
Yes,
but can you show this issue of mistake in any of your documents? You have filed your written, your affidavit in opposition.
my lord.
You take a plea that it was a mistake.
Yes, my lord.
And who, by which notification that plea has been accepted by the state, that the state may committed a mistake?
Yes, my lord. It is in, my lord, para 7, my lord.
No, para 7 is your statement.
Yes, my lord.
You see, when you have a policy,
Yes, my lord.
you have issued notifications
My lord.
that there was a mistake, which authority accepted it, before whom it was placed.
It was placed before the chief secretary, my lord. Chief secretary, my lord.
Where is that document?
My
Why
lord,
would you withhold that
it
document?
can
then?
be seen from, indication can be seen from page 154, my lord. Of file noting, my lord.
154.
154, my lord. Annexure 1, my lord. This is our file noting, my lord. Note number 15, my lord. The notified list of 588 staffs of DRDA absorbed in RD department has anomalies with which the learned CS, Chief Secretary, in the review meeting of the department held on 3/10/2024 has directed for causing rectification in 4 weeks' time. In view of this, SRD may like to constitute a committee to verify the service records of all the staffs of DRDA absorbed in the RD department and fix a time to submit its report to SRD for further decision. Now, note number 16 is the committee members. Director RD, Joint Director RE, Deputy Director RD. This secretary has constituted 3-member committee. And then, page 155. Here we have detected many mistakes. May come to cell number 4, A, we have mistakenly included retired employees also, for which another writ petition is pending, one. He is also claiming parity, one writ petitioner. Retired employees also we have included, page 156, then resigned employees, B. Terminated employee also we have mistakenly included.
No, come to that.
Deceased employee also, In respect to petitioner, clause A, may please come to clause A, incorrect designation.
Come to this order. Page 102.
Page 102,
That is this is the order.
Yes, Here
you don't say that. What was the compelling reason to say that? You say just you amend it.
Yes,
So the ground now you are trying to urge that there was a mistake.
Yes,
In your notification, you don't admit that mistake.
Notification, we are saying this is amended, revised list of DRDA.
We don't even have this.
But in the file noting we have, it was the concern of the Chief Secretary.
You're not referring to any of the notifications here.
Finding mistake, we have corrected this. We have issued this notification by following due process. My lord was right in observing, mistakes can be corrected, Mistakes are mistakes. It can be corrected, by following due procedure.
No, but for that you'll have to withdraw it.
We have amended it, yes.
If there was a mistake, then
Yes.
in the notification, whatever you have done, will it not affect that notification?
We have amended it, It amount,
No. You have issued a revised list.
This may be treated as amended, May I read,
Yes.
Order, 1st May 2025, in pursuance of the page 102, in pursuance of approval of cabinet in agenda item number in its meeting 2nd April 2025, as communicated through minutes number byte number so and so, 2nd April 2025, the governor of Arunachal Pradesh is pleased to amend the notification number so and so, dated 22 February 2024, and approve for issuance of the revised list of 565 employees as shown in the annexure 1. We have amended the first notification. In fact, there is no their appointment order, appointing them as a on promotion, to the post of APR. In the writ petition also, they cannot demonstrate that,
That means you run the government as per your wish.
Not my wish, my lord.
Otherwise, all the.
There was a glaring mistake, my
How
lord.
can be in thin air?
My lord, may please come to page 155 of our affidavit, my
One?
lord. 155, my lord. Of my affidavit in opposition, my lord. Respond number 2 entry, my lord. There was many mistakes, my lord, in the first notification.
Yes.
My lord, serial number 4, my lord. Retired 4A, my lord, retired employees, my lord. They were also included, my lord, in the first notification. And next page, page 156, my lord. B, my lord. Resign employee, serial number 20, my lord, is also there. My lord. Those who have resigned, whose name has also appeared, my lord, in the first list. My lord. Terminated employee, my lord, serial number 370, my lord. Deceased employee, my lord. They were also found in the list, my lord. And E, my lord, non-DRD employees incorrectly listed, my lord. Non-DRD employees were also included, my lord. They were also rectified, my lord. Then F, my lord, incorrect designation, which is related to petitioners, my lord. And G, my lord, non-existent employee, my lord. (316) was a non-existent employee, yes. And H, my lord, duplicate entry is there, my lord. Name correction was required, my lord. And excluded employees, my lord. Those who were excluded in the first notification, they were also included, my lord. J, my lord. These 6 people were, my lord, excluded in the first notification. After issuance of first notification, there we have received many complaints, my lord. Representation, my lord. Upon that, we have, my lord, constituted a committee, my lord, 3-member committee, my lord, which was headed by Director, my lord, Director RD. My lord. So, my lord, I have one judgment, my lord. (2008)
Citation. Yes. There. Citation. Citation. 2008.
Yes.
2008 2 SSC, page 750, my lord. Paragraph 32, my lord. Which holds, my lord, mistakes are mistakes. It can be corrected by following due procedure. May I read, my lord? It is true that mistake was of the department and the respondent was promoted, though he was not eligible and qualified. But we cannot countenance the submission of the respondent. Mistake cannot be corrected. Mistakes are mistakes. They can always be corrected by following due process of law. In so and so, it was held that if erroneous promotion is given by wrongly interpreting the rules, the employer cannot be prevented from applying the rules rightly and in correcting the mistake. It may cause hardship to the employees, but the court of law cannot ignore statutory rules. And if my lord allows me to submit on res judicata.
Res judicata, you have to file an affidavit, bring it on record. We won't hear an plea of maintainability without putting the other side to notice.
Other side is well known, my lord, because they are on appeal, my lord. Before this on record only. Read appeal.
Maybe, but still there is a procedure to be followed.
Yes, sir.
That plea would be alternately rejected. You can raise the plea, we are not stopping you from raising the plea, but we are putting you to notice that the said plea would be rejected.
My lord.
So we take note of your submission, but ultimately we will be rejecting it.
My lord, can I please come to page 87, my lord, of the writ petition. Sorry, my lord. Page 78, my lord. 5 series, my lord. Annexure 5 series, my lord, is their appointment, my lord. Order. Nowhere they have been appointed for permanent basis, my lord, or they were promoted. They were only given charge, my lord, to look after the charge. They were given the post to look after the charge, my lord. Since at that point of time, they were not eligible to be promoted, my lord, or given the charge also, my lord. This initial appointment will be, my lord, '77, my lord. Approval for look up to the charge of APR in DRD. Paki Kesang, my lord.
You see, we fail to understand,
Yes, my lord.
if you have sanctioned posts, why will you have appointments made for, by allowing people to temporarily hold charge? There was some very good reason. And for how many years they've been holding charge?
They were given only extension, my lord. 6 months extension.
Tell us the period, from when to when?
From
7 years?
2021. From 2020.
For a year, my lord, only.
From 2021, my lord.
2021.
My lord. Up to 2024.
So you have posts, you don't fill it up.
But they were never promoted, my lord. It is in the wisdom of the employer, my lord. I cannot say, my lord.
Private interest. Interest of the employer, but private interest.
My lord. They could have filed writ petition for, my lord, with another cause of action, my lord. But, my lord, this notification, my lord, of 2025, my lord, 1st May 2025, there is no mistake, my lord. We have corrected the mistake, my lord. Acknowledging the mistake done in 2024, my lord. 22 to 24, my lord. 22 to 24, my lord, there was many mistakes, my lord. And by way of 1/5/2024, or we have 1/5/2025, we have corrected the mistake, my lord.
Okay. Anything in reply?
My lord. My lord, the plea of res judicata, though Lordship said Lordship will not consider. My lord, the writ petition which my learned friend is referring to, my lord, was a transfer and posting. The impugned order, my lord, was 8/10/2024 of a transfer order. My lord, in which writ petition, the gazette, the notification at page 102 was not even in existence. So therefore, it could not have been taken up there. And that is why on getting to know of this gazette notification, which we got to know during the pendency, we have challenged by way of the instant writ proceeding, my lord. And my lord, there's one aspect which my learned friend has referred to, the office notes. These are all at the director level, which he has pointed out before Lordships from page 154 or page 154. These are all of the director level. This is an amendment, as Lordship has, it has fallen from Lordship's mouth. The previous notification was not withdrawn. The previous absorption was not withdrawn. It was simply a revised list, which they have amended. And in this particular, my lord, the anomalies which they point out from page 155, if my lord comes to page 156, serial number E, my lord, sorry, man.
Yes.
Serial number E, non-DRDA employees incorrectly listed. They have taken this, but they say serial number 61 and 63, the employees are regular extension officers of RD department and looking after charges of APORE. They are not DRDA employees. Therefore, they have corrected. Then serial number 62, employees are regular assistant officer technical of RD department, not DRDA employees. But the writ petitioners which Lordship has seen in the previous writ petition, my lord, in the judgment, my lord, which was 4/9/2019, the list which lordship has compared with the list of petitioners who are sought to be, they are all DRDA, regular Rural Development Department employees. They are on deputation, as noted by lordships in the previous writ petition, my lord. But they are absorbed as DRDA employees, though they are deputationists from Rural Development Department. And lordship has directed them to be treated as deputationists. But they are not, they have been absorbed as APO. Lordship has seen those serial number 58, 59, 62, 63, and 560. They are all the petitioners in writ petition 105 of 2016, 106 of 16, and the entire list, my lord. But they have not applied this. They have rather discriminated us. So therefore, the basis of issuance of this revised list is incorrect, my lord.
Which page you are referring to in the last submissions?
My lord, serial number E at page 156.
My lord, one thing I want to clarify, my lord.
Just
Yeah,
a moment.
yes, lord. Page 156.
No, you're referring to absorption. Where is that?
My lord, page 104, my lord. Which lordship had read in conjunction with page 125 onwards, the names of the petitioners in the previous writ petitions, wherein they had sought, they had challenged their repatriation to the Rural Development Department. Page 104, my lord, from serial number 58, 59, 62, 63,
Yes.
and 560. They were all the petitioners from page 125 in the writ petitions 105, 106.
You are referring to which order?
Order date, my lord, it starts at page 125. The writ petitioner in writ petition number 105 of 2016, Hura Kaku. Then down below, writ petition 106 of 2016, Kirli Bui. Next page, my lord, 108 of 2016, Konyo Dada. Then, my lord, next page, my lord, 119 of 2016, Thomas Tasso Bath, he's Titi Bath. Then, my lord, page 128, WPC 122 of 2016, Dongche Baka. My lord, all of them at page 129, lordships had reflected the basis or the background of that case, my lord, paragraph 2, my lord, by which they were sought to be repatriated to the Rural Development Department. Paragraph 2, if I may again read, my lord. The writ petitions, lordship finds it at page 129.
No, but the observations of this court in page 130, paragraph 6.
My lord.
This proceeds.
No, from here, sorry, madam. From here, what I am trying to project, my lord, is that they are deputationists from the Rural Development Department. And they have been, towards the end of this judgment, my lord, leaving it open to the respondent authorities to deal with the petitioners in the manner provided under the rules, insofar as deputationists are concerned. They are deputationists as extension officer from the Rural Development Department. But they have been absorbed as APO RE. That is the discrimination which I'm seeking to project before lordship. Though they are deputationists, on closure of the borrowing department, they have to be reverted back to their original posts in the Rural Development Department. They are being absorbed in the Rural Development Department, but they are being absorbed as APO RE. But the same yardstick has not been applied to us. And my learned friend has said that there is no appointment order. Sorry. My lord, page 79. Sorry.
Yes.
Page 79. Of course, this is in respect of one of the petitioners. This is an order dated 27/10/2021. In pursuance of the government approval letter number so-and-so dated so-and-so, Sri Sai Koten is hereby appointed as APORE under DRDA Leparada District Basar, pay band so-and-so with great pay so-and-so and other allowances and concessions as admissible from time to time. There was an appointment order. Though later on, my lord, he has again been given temporary charge. Later on, my lord, at page 81 is of 2022. Page 81, my lord, this is 4th April 2022. Directed to convey government approval of Sri Sai Koten under DRDA for a further period of 1 year in his own grade and pay. Then, my lord, page 82. This is again, my lord, approval in his own grade and pay. But of course, these were for specific periods of time, up to, my lord, the absorption, initially, my lord. Okay, my lord.
My lord, one thing I want to clarify, my lord. APO Tech and APORE is different post, my lord. APO Technical and APORE, my lord. Both are different posts, my lord. APO Technical comes under the RD department. APORE was under DRDA, my lord. My lord, I would like to submit one thing, my lord. One submission, my lord. Since this is a
No, but
service,
this Page 71
yes, my lord.
is an appointment in DRDA
Yes.
as APORE.
Page 79, my lord.
Yes.
And subsequently, my lord, may kindly consider the page 80, my lord. It has to be read in consonance, page 80, 81, my lord. Page 79 should not be read alone, my lord.
80 is previous, my lord. 80 is September, 79 is October 2021.
He was given extension for 6 months, my lord. And then page 81, my lord. Extension for look after the charge of APORE, my lord. Subject, my lord. Page 79 may not be read alone, my lord. It should be read with page 80 and 81, my lord.
Yes.
My lord, last thing, my lord, this committee report, my lord, which they have never challenged, my lord, by way of amendment or something. My lord, service matter is very technical, my lord. It is not violation of Article 21, my lord. They have to challenge this, my lord. This committee report, my lord. They have not challenged this committee report, my lord, which is final, my lord. They have to put challenge to this committee report, my lord. Unless page 155, my lord, of our affidavit. Committee report, my lord. Annexure 2, my lord. Basing on this committee report, my lord, they have been excluded from the list, my lord. they've been given their original designation, my lord. But they have to challenge this committee report, my lord. They have not put to challenge this committee report, my lord. Page 155, my lord.
No, it's not required. They'll have to sell the order which has caused harm to them.
Yes, page 155, my lord, is causing them hardship. my
150
lord.
is only a committee report. They have never made it public.
1525 is the outcome of this, my lord, committee report, my lord. Because
No,
the
no.
scrutiny was done by the committee, my lord.
That's not the way.
My lord.
You stand on this side and then you argue the same point.
My lord, so my lord,
That means if I want to challenge a government notification, what I have to do is procure all the contents of the file, the reports and all, everything, and then everything you have to challenge. Right from the, what you call a note or from a peon.
no, my submission is, my lord, like that.
No, I
If
understand.
there would have been a violation of Article 21, that would be different, my lord. Yes.
That would mean that I have to look into the office notes of a peon till the chairman of the committee and then make a challenge. Is that you are proposing?
Or they have the option to amend the writ petition, my lord, to challenge this.
No.
My lord, Bachitter Singh
That would show us immaturity in your submission.
My lord, service matter, my lord, are generally technical, so
No, it's not a question of technical. Have you made in the notification, have you stated about this? If I tell you that this is a manufactured document, then what you do? Have you referred in your notification that there was a committee report, there was an investigation done, and then we found out mistake, and therefore this comes? We have asked you that question.
Right.
Have you referred it? No. You keep it silent. Everything is under the carpet.
No, my lord. We have formed the committee.
No, that's why we use that harsh words of your immaturity in their submissions.
No.
What will a person challenge? Anything which is in public domain. Is this in public domain?
They had the option to file RTI, my lord.
Don't tell us.
My lord.
Don't tell us. We take a serious objection to your submissions. That means we'll permit you to do all the illegality, and it will be the petitioners who will do the RTI, get the documents and challenge it. You forgot about the MS Gill.
No.
The order which is under challenge will have to be a speaking order. You can't add or subtract a government notification by any affidavits or any explanation. This will be covered by that. When we set aside your order, this will automatically go. We don't have to pass pass a writ against committees. Are you suggesting that the court would be powerless to issue to catch the notification without challenging that report?
No, my lord.
No. We know how to use our power. If we accept this submission, all these ancillary things would go automatically. When you challenge a a rule, what do? You go to the do RTI, go to the parliament, ask them what has transpired. You ask the question number, answer. Is that how you prepare a writ petition?
No.
No, that's why. This thing doesn't impress us. It's only exposes something which we don't want to say. If that is what you think as a government advocate, then all the actions of the government would become questionable. You can't have two parameters. Then we say that any order passed, everything will have to be disclosed in the order itself, along with the file notifications. You want that order from the court?
No.
Then we'll pass orders. Then any government notification coming will have to be accompanied by an office note. All the preparations done, all the notes, all the discussions made, everything has to be made a part of record. Because the government advocates has made that submission. We'll pass in on orders. No, don't tell us. We know how to use it as a power.
Lord, in fact, in Bachitter Singh, if I may, my lord, in Bachitter Singh, my lord, even notes of the ministers are not final. Bachitter Singh, 1978, my lord. Yes, my lord. That was laid down, my lord. It's a final order which needs to be challenged.
This could be manufactured any time.
My apologies, man.
You don't put the, that's why you don't place those records.
Right.
Yes, I heard Mr. P.D. Nair, the counsel for the petitioner, as well as Mr. B. Pichal and counsel for the respondents.
R2,
Judgment is
2 and 3.
RWD. You are for?
Respondent number 1, Your Lordship.
Respondent by Ms. P. Pango. Okay.
Deeply.
God bless.
Item number 13.
Yes, Mr. Patin.
Well, please.
This writ petition was filed on 6/4/2026 and 25/5/2026 also it was fixed. 27/5/2026 it was also fixed, but they have not filed any affidavit. Even then, this court has passed an order dated on 27/5/2026 to produce the record. Produce the record. Now, by way of filing this writ petition, I have challenged the transfer order, which has not been done in public interest.
You were transferred to this post on which date?
This transfer has not been done, not in the agencies of service.
So that's okay. What you are asking is that when you joined this post at Pasighat,
yes,
then when did you join this post? Since when you are holding this post?
Almost 14 years, 12 years.
Then
14 years.
Then
here, my lord, the question of tenure of posting is not the issue and it is not the relevant here in the case.
There is a transfer policy of 2 years after that. If
no, my case is that the transfer which is having relieving me, she is not my cadre. She is my feeder post. She is in my feeder post. I am in the promotional post of this person. She is sub-divisional food and civil supply officer.
Then it's covered by decision of this court. You can't transfer a person to a post when he is not holding the equivalent post. He is
No,
already in charge.
my lord, that was different thing, my lord. Actually, the issue is that person who was already, this private respondent was already holding the post of this.
No, it
similar-
will always be a substantive post would be SDF CSO.
No, your lordship, in fact, he has not been reduced in his post, my lord. He has not been reduced in his grade. He has been transferred in the same cadre, and he has already joined there, and he is functioning in the same cadre, my lord. Place of posting, rowing, my lord. It is not a case where a junior has been just picked up and placed in his.
No, the respondent number 4,
my lord,
is holding a post junior to that of the petitioner.
No, his substantive post is junior, my lord. One
It can't be the case. There's a judgment of this court. What is that citation?
Citation is, my lord.
The division bench and single bench also holding the same thing. Transfer would be only on the your person is holding the same post.
Konyak ka mga mati. Konyak ka. Konyak ka. Yes, my lord. Nyapun Konya, this is the 257 AP 2016. WPC number 257 AP 2016. Yeah, this is the right.
We have a copy of this. We have copy.
No.
Yes.
Yes, my lord. Here, I am belong to Group A officer. He is belong to Group B officer.
We got your point.
And transfer is normally it is done with indicator.
We got your point.
Yes.
Mr. Jamo, what is your response?
My lord, in fact, in Arunachal Pradesh, my lord, sanction post is only 18, my lord. Sanction post is only 18, and there are 26 district, my lord. If this ratio is applied in such circumstances, my lord, it will amount to block is telling the normal procedure of this normal
It is the
process.
wisdom of the government not filling up the post, not creating posts. You are
my lord,
creating districts and you are not posting people. No posts are being created.
Yes, my lord. That is the problem here. And he has already completed there for more than 14 years. And arbitrariness and other defenses like
No, but you can't do it. Once
Posting-
you can't do
posting
it, there's a
someone-
judicial pronouncement of this court. We'll have to abide by that.
my lord. In fact, both the parties has complied and they have already joined. The private respondent has also joined there.
They'll have
And
to
the
make way.
petitioner has also joined in his
They'll
due
have
place
to
of
make
posting.
way. They'll have to make way. What is illegal has to be declared to be illegal.
My lord, in fact, it should not be this in terms of Supreme Court judgment, my lord. It should not be termed as illegal, actually. Your lordship.
Which citation you are giving?
Actually, we are not ready with the citation copy, my lord. We can go with the Union of India versus SL Abbas, my lord, 1993 4.
1993.
Yes. SCC 4. Volume 4.
Volume 4 SCC.
Yes.
Okay.
357, my lord. And even this Supreme Court has this observed in State of UP versus Govardhan Lal in 2004, volume 11 SCC. my lord.
Govardhan Lal was not dealing with this issue. Govardhan Lal merely says that one doesn't have a vested right to be posted where.
Yes, my lord. Yes. Yes. And he is keeping him there permanently would amount to casting a vested right to posting, my lord. He has already completed 14 years, my lord. That is our stand.
No, but you replace him with someone of equal cadre.
No, my lord, this person is already holding the post of this in charge, holding the post of district food and civil similar
You see,
equivalent.
charge
post, my
can be
lord.
anybody. Tomorrow, if the government thinks that instead of all highly qualified people, we'll have a class 8 person to hold that post of chief engineer.
No, my lord, they are qualified actually. This private
We
respondent.
shall be in charge.
In charge, my lord.
No, no,
It
that's
means
why we are telling you that if the government feels at appropriate time, that it is, this post would be held by a person who is not qualified. Will it give a vested right to displace somebody who is holding a, who is higher in cadre?
My lord, your lordship goes through the record. Actually, I was called with this director to produce the record, my lord, of this transparent process, my lord. If your lordship could go through it, it would, your lordship might reconsider the this decision, my lord. Even in Silpi Bose case, my lord. Government servant holding a transferable post has no vested rights, my lord.
Silpi was the same thing, but it doesn't.
My
deal with
lord, my
that
lord,
issue. It also doesn't deal with that same issue.
My lord.
Governor Lal and Silpi Bose, we read together normally.
My lord, actually, there is no statutory violation, my lord, in transferring him because he has already he has already completed this 14 years there.
1993, 4 SCC SL Abbas.
1993.
4 SCC 357 is the case of SL Abbas.
My lord. For SCC 357, my lord.
357, that is case of SL Abbas.
Yes, my lord, SL Abbas.
He is not asking for a charge. You send him somewhere. He says that merely you want to displace him. Do with a person of equal rank. You don't confer rank to this. Why don't you promote the person who you are trying to bring in?
For promotion, my lord, we understand, my lord. For promotion, my lord, we will have to, this department needs this substantive post, my lord. But this person, private respondent, is also a qualified person. He is also qualified to be promoted, my lord. But for want of this sanctioned post, his promotion, though qualified, has been dispensed with, my lord. Now, before that, prior to that, my lord, it is not that we have just picked him up from somewhere and placed him in front of him just to replace him. Not that, my lord. This person is already holding the shares of District Food and Civil Supply officer, and this gentleman, petitioner, has already completed 14 years.
That was the first view taken. See,
both of them are operative, my lord.
the first question we asked was the number of years. But then the issue turned out to be a person who will be displacing him who was a junior in rank.
My lord, there is a standing order also, and standing order is in additional affidavit. Additional affidavit, page 38.
You see, first line you are when you are showing us this.
Additional
I guess is interference by a politician.
No, no, my lord. Nothing like that.
I don't know. The first thing we saw in this, I have not even flipped up the pages. At a cursory glance, we find that first note relates to interference by a politician. Where is that guidelines you are referring to?
Yes, page 38, my lord.
38.
38. And the pile process also, here in this case, there is a pile of process. Here, the SDFCOs holding as in charge DFDO shall not claim for further posting against the posts held by regular DFCSO. Means, no doubt, when there is no sanction post and they have been adjusted as in charge of DFCSO, but they will not have a right.
No, he is not claiming a right.
Yes.
It is the
Against the post held by regular DFCSO. The SDOFCSO functioning as in charge CSO shall invariably designated himself or herself as in charge, DFDO in all official communication. Third, the in charge functional arrangement is allowed in cases of exigencies of services. Due to shortage of manpower, the SDF CSO shall have no right to claim for regular appointment to the post of DFCO. Means I am holding the post of substantial posts. Where there is no sanctioned post, there he was adjusted as a DFCO, that is at Anini. Does it mean he become my cadre? Does it mean he become the class 1 officer, group A officer? Still, he is a group B officer. He being a group B officer, he cannot be a reliever. There is the illegality. And when I am saying that this transfer is not, he has mentioned in his application that he needs the posting place at Pasigat. This transfer has been made only to accommodate him. And what is the reason? Ground of the transfer was that because of health condition. Now, the health condition and accommodating of one individual interest cannot be a public interest. In a transfer, that's right. That just to accommodate him, just to help ground. Why they should write public interest? And when the file was put up, there is no such mentioned place of posting at Pasigat. The file put up is also annexed.
You see, this can't be the considerations. For whatever reasons the government feels that a person requires a transfer because of health reasons of his mother. Mother is 90 years old. And when the transfer orders are made on public interest, it's quite perceivable. There may be people with a lot of issues.
And he took the help of the public leaders.
Private interest.
MP, he took the help of MPs, he took the help of MLAs.
When you say about this, I will not name the officer, he's a judicial officer working under our jurisdiction. He suffered a cancer. He was posted in the judicial service. Within 1 year, he had cancer. And he made a request to keep him at a particular place because of exigencies of his, for the reasons of his treatment. We accommodated that. And he got cured. After a year of treatment, he got cured. The person continued to serve. And then he had the second attack of cancer at the same place. And the hospital where he is being treated said that for this, he will need a better treatment and therefore we don't have it. And therefore there was only one option left, to send him to a place where this was available. And we accommodated that. He undertook treatment for about less than a year, about 10 months. He is again cured. So do you think that we did not do public interest in transferring the person to a place to make him recover?
She has got his posting place. Even at Pasigat, she is a sub-divisional officer. She is not the district officer. So there is a posting place at Ruksin. There is a posting place.
When you say public interest, then we are giving you that public interest may arise. We think about few people. We think about people to be accommodated. At times it is a necessity. Even to save life is a public interest.
This transfer has been made as per his own request.
That's okay.
And
he has an interest.
And apart from that, he took the hell of the politician.
If he has a 90-year-old mother to be treated who is having asthma, what is wrong in the person approaching a politician to get some help to be there?
And he being a sub-divisional.
Make submissions on law, but don't tell us about these things. These things.
He can be posted Pasigat as a sub-divisional
You can make, but
food and sales supply officer.
You have to take care of elderly people in the family is also public interest. We take
But he should be in my cadre.
That's okay. That make argument you can make, but please don't make submissions on people who are aged and then require some assistance. This is something very painful. Because today it is his mother who is going old. Tomorrow it will be I. If I require some assistance, if my son is in service, he asks for a place of posting just because his father is suffering. It can't be so bad. Age is something everybody will catch up. Everybody will make interest assistance. It can't be said that it is not in public interest.
Only my submission is that he being a Group B officer, he cannot replace Group A officer.
That argument you have taken. Yes, Mr. Jamo.
My lord, if I would repeat my argument, my lord, if that stand is taken, my lord, applying that Koji case, my lord, that will amount to still, my lord, in such circumstances, my lord, the normal process of transfer and posting, my lord. No doubt, there was an application from the private respondent, my lord, we admit. And your lordship has rightly pointed out, such applications cannot be merely thrown away. We have considered his case, my lord. This gentleman, petitioner, has already completed, long completed and overdue for his transfer, my lord. That's why he has been transferred. This petitioner has been transferred. And if his argument is accepted, my lord, after his transfer from Pasigat to Roing, my lord, there is no available this transferable officer of the same cadre, my lord, same grade, my lord. Then Pasigat will have to be made by, of course, someone in charge. There is natural outcome, my lord. Even if this private respondent is not posted there, my lord, when the petitioner is posted out from his place of posting Pasigat, where he has already served for more than 14 years, my lord, someone has to be placed there as in charge, my lord. Now, it is a position, my lord.
But we have a judicial precedent. It says this can't be done. You'll have to assail that judicial precedent. You can't take a view which is contrary to the one already taken by the court. This bench is not sitting in appeal over the ratio laid down
my lord,
by
yes.
by the other coordinate bench. How can you take a different stand? This is not an isolated case in the country. Maybe in other states also this has happened. Has this been permitted by any other court, any other judicial pronouncement that a person higher in rank can be displaced by a person lower in rank?
No, my lord, the circumstances relied by him is different, my lord. Actually, it is not. It doesn't fit into this present case, my lord. It is a case where the person has served overdue, my lord. His posting has been, but he is overdue for posting, and more than decade, my lord, he has already served. And in that case, my lord, there was no such overdue, my lord. We have to represent that, my lord. And regarding that, this, your lordship, this transfer posting, impugn transfer order also, my lord. Please come to page number 17. Page number 17, my lord. Normally it is done, and there is precedent, my lord. There is precedent in the department. Page number 17, my lord. Page number, read petition, my lord.
Yes, we are there. We are there at page 17.
Yes, my lord. Petitioner is the serial number 1, Bijoy Patil, my lord. He is DFCSO and Pasigat to Rowing, my lord. He's posted there. And Mudang Bagang, SDFCSO. In charge DFCSO. In charge DFCSO. He has been placed there, my lord. And this private respondent, Dana Iran, SDFCSO. In charge DFCSO Anini is posted as in charge, my lord. It is natural outcome, my lord, when the private this petitioner being overdue for posting, being posted out, someone has to be placed there, my lord, in this, to man the post, my lord. Someone has to be there. Even if this private respondent is not placed there, obviously, we will have to place someone because we cannot keep it this unmanned, my lord, that post, my lord. And your lordship, please come to the record I have produced before your lordship, my lord.
Yes.
In
most of the pages, you will find the same name coming up again and again.
My lord.
Interference by so-and-so, interference by so-and-so.
My lord, page number 5 of the record I have produced before your lordship. My lord, I beg pardon, my lord. Actually, the one I have marked was for my this reference. Instead, that I have this inadvertently placed before your lordship, my lord.
Yes.
Clean one is with me, my lord.
Okay, just give that. Substitute that.
Actually, here we have been this admonished, my lord. This is marked and this indicated pages should not be placed before this honorable court, my lord. Please come to page number 5, my lord.
Now, please tell us, in your department, this Food and Civil Supplies Department,
my lord,
if somebody is an in charge,
my lord,
does he get the salary of the substantive or the higher post?
No, my lord, no, my lord.
No.
That cannot be permitted, my lord. And
that's not permitted.
No, my lord.
So therefore, how can he displace a person of higher rank? He'll take charge.
In charge, my lord.
We understand, but you see the situation where a person is, Mr. Patil says, Group A. Group A will hand over charge to Group B. Because in our judicial system, we don't follow that.
No,
what happens is that if the relieving officer is of a different rank, then we say that he will hand over the charge to the district judge. A charging charge cannot be given to a junior person. At least judicially, we don't follow that.
My lord.
So therefore, we don't know.
There is some different variation, my lord. Of course, their head is deputy commissioner. Of course, deputy commissioner is not handed. Charge is not handed over to the deputy commissioner. The person who is relieving is handed over with the charges, my lord. That we understand. But there is some variation in our judicial service, my lord. Please come to page 47, my lord. Page 5, my lord.
Yes.
Not 47, my lord.
Yes.
It has been written by the director of the Food and Civil Supply Respondent this department, my lord. Dana Iran, SDFCSO, has been serving as in charge DFCSO Anini since September 2021, where Bijoy Patil, DFCSO, is serving as DFCSO Pasigat since June 2014. And hence, their transfer and posting is overdue. There is precedence of posting of SDFCSOs as in charge DFCSOs in the district where there is full-fledged DFCSO and no SDFCSO junior or senior to Dana Irang is posted at Pasigat DFCSO office at present, my lord. Dana Irang has been praying to the government for his posting at Pasigat as in charge DFCSO in view of health medical problem of his son and mother, who is spending last part of her life due to old age too. In view of the above, it is proposed from transfer for transfer and posting of Dana Irang, in charge DFCSO Anini, Dibang Valley to Pasigat, as in charge DFCSO Pasigat on humanitarian medical ground. Vijay Perdin, DFCSO Pasigat, is sent to rowing as DFCSO and Mudang Bagan, in charge DFCSO rowing, Lower Dibang Valley to Anini as in charge DFCSO Anini, please, my lord. On this basis, transfer has been initiated, my lord. Your lordship, these three people has been rotated, my lord, and the place this gentleman petitioner has been posted, there also he has been posted at the same rank, my lord. Now, question that a person junior to him, though holding the equivalent post in inches, becomes remote, my lord, when it is seen that he is being posted there as regular DFCSO in same cadre, my lord. So, and apart from that, my lord, department has clarified, my lord, that we have precedents for for administrative exigency, my lord, that I have cited before your lordship some while ago, that only we have sanctioned, we have been given with the sanction post of 18, my lord, and 26 districts are there. Obviously, functional and insurance has to be made for complete this public service, my lord. That's why this person was already serving as in charge DFCSO at Anini, my lord. It is not that we have just suddenly picked him up and put him in place of the petitioner gentleman just to oust him from his present last place of posting, my lord. And now situation also, your lordship, take it into account, my lord. Situation has also drastically changed, my lord. This private respondent has already joined and serving there for more than almost 1 year or 1 month. And this gentleman petitioner has also
That SL Abbas has said
released.
That SL Abbas has said that once you join the posting and then challenge it.
Yes, my lord.
So the Supreme Court permits that challenge. SL Abbas is the authority on the point,
My lord.
which you have cited. What does SL Abbas say? It says that only,
my lord,
that a person has to first join and then make a challenge.
But apart from that, the other lines has been, this, unless the transfer order is shown to be malapite or in violation of statutory rules. SL Abbas says, my lord, the court should not interfere, my lord. Your lordship, I have not, actually, I was directed to come with the record, my lord. That's why I am up with the record. If this honorable court give me time to come with my
We have
full argument, my lord.
sufficient time. That's why you see there's a judicial order saying that this
My
will be
lord,
attempt to
then, my lord, let me counter the argument tomorrow with my full text, my lord. I'll come.
Tomorrow is a division bench day.
And second half, my lord. Day after tomorrow, then, my lord. Since both of them have already joined, and there would not be much difference, my lord. Day after tomorrow.
Every day matters.
I'll bring all these judicial precedents before your lordship and satisfy you. When he has served there for more than 14 years, there cannot be question of mala fide, my lord. That is my simple humble understanding, my lord.
Nobody's selling that position.
My lord.
But had you not substituted him by a person junior in rank, your argument would have been perfectly right.
My lord, actually, we are sort of sanction post, my lord.
That
We
is
cannot
wisdom of the government.
elevate anyone, my lord.
The government may like people to be ad hoc.
My lord.
That is why this names I don't want to read.
My lord.
These names are coming up of people who are interfering, who are outside the department, but having a clout over the department.
No, my lord. That was an old story, not acted upon, my lord. In the division bench also taken note of that, my lord. Your lordship will go through the division bench observation, my lord. Division bench also has taken note of that, my lord. para 9.
Yes, my lord.
Para 9, they filed one this application, my lord, for interference, my lord.
Yes.
The division bench has clearly said no interference.
Yes.
That's okay, but since Supreme Court has now said for early disposal.
Yes, my lord. Then they are
bound to
tomorrow
do it.
will come by, my lord.
It's bound to do it.
Since we have placed your lordship, placed before your lordship this record, my lord. May I read para 9, my lord? Para 9, my lord. Of the judgment just order just I have placed.
Reachable 25 doesn't matter because now we are hearing the entire matter.
My lord, come to the property of my additional affidavit. Here,
Let him complete, Mr. Martin. Mr. Jamo is making his submissions.
My lord.
Please allow him to do it.
This single judge and division bench, both of them has taken note of that, my lord. The interference and all, my lord. May I read one line, my lord? So that cloud is cleared, my lord.
Yes.
The learned single judge has found that the elected representative made the representation, a request for transfer of the respondent number 4 about a year ago, and the same would not be relevant to decide in the case of transfer, who is affected in administrative
Yes.
exigency. The respondent number 4 has been serving as in charge the FCSO from at that anterior to 19/3/2026, my lord. Here is the point, my lord.
yes.
Though he is in the substantive rank and post as the FCO, nothing has been submitted as regard violation of any statutory rules. That's why I was harping on SL Abbas case, my lord. Or
Because this
no,
is
there is
when the
allegation of malafide, my lord.
when this. Okay, we'll take it up tomorrow.
Okay,
After the end of the division bench, we'll take it up.
okay, my lord. I'll come up with this complete text, my lord.
Yes, yes. Give us a list of books on which you are relying
Sure, my lord.
in advance. Submissions of Mr. Anup Patil and Senior Counsel, assisted by Mr.
Bothon Gogoi.
B. Gogoi, Learned Counsel for the how do you spell your name? B. Gogoi. Your name is not there in the Pakatama. Okay. So B. Gogoi, Learned Counsel for the petitioner. The submissions of his submission is concluded, reserving right to reply. Mr. B. Jamod and the counsel for respondent number 4. The submissions of Mr. B. Jamod and counsel for respondent number 4 remains inconclusive. Who is appearing for the department?
My lord. T. Jamo, my lord.
No, you are appearing for the department.
My lord.
But your name is shown against respondent number 4 only.
Respondent number 4, I'll put a private respondent.
You are for respondent number 4. Your name?
V. Jamo.
Okay.
Lordship, here also, I would like to.
Okay, Mr. B. Jamo for the respondents 1, 2, and 3, and Mr. V. Jamo. He'll be Mr. T. He'll be Mr. V. Jamo for respondent 4. Mr. Submission of Mr. T. Jamo and counsel for the standing counsel for the Food and Civil Supply Department remains inconclusive. List as a part had matter on 10. Sorry, it will be 11/6/2026. Yes, what do you want to say?
Clear the query made by this honorable court also. Whether the substantive court can be like, we're making an example now, whether the district additional judge can just hand over the charge to district judge or not. Also, in regard to
No, he can take charge. No issue with that. But can he be transferred? Can a additional district judge, can a rank below be transferred to take over the charge of a district judge? We can appoint them. Today, if a district judge retires, what happens? A person next to it, that there is a charge post cannot be left vacant. So tomorrow, if he is retiring today, from today, we are appointing another person. He's a charge post because he'll be a DDO. So post of DDO cannot be left. So therefore, in charge we can accept. But can he be transferred? That is the question. For a moment, we are not keeping any charge post. Otherwise, the salaries will not get, people will get.
Mhm.
So charge post can't be kept without an officer. There's no gap. At least in our system, we know there's no gap. A charge officer would be either the district judge, or he would be chief judicial magistrate, or he may be a tribunal, MSCT, family court. They're all charge post. The entire salary comes through him. Holding a charge post and being transferred from a charge post to a substantive post, that's the issue. Okay. Tomorrow. We'll see.
Item number 16.
Please, Your Lordship.
Yes.
I'm for the petitioner, Lordship. The respondents, Lordship, except for 5, 7, and 8, all have filed affidavits. If they are not going to file affidavits, matter may be listed for admission on next week, 17.
Yes. Except, you see. And the General Counsel for the petitioner and Ms.
T. Wangmo.
T. Wangmo, the government advocate, are present. Apart from respondent numbers 4, 6, and 9,
Lordship,
no other respondents have filed their affidavit in opposition.
Lordship, on 31/7/24, the respondents 1 to 3 has said that they will go by the affidavit of respondent 6. So they're not going
We
to
are not
file.
on that.
Yes, Lordship.
On record, there is only, apart from respondent 4, 6, and 9, other respondents have not filed their evidence on affidavit in opposition. So accordingly, as the case is ready as regards service, this is the matter in the admission column on
17, next week.
17.
Lordship, there is an interim order that may be continued.
Interim order passed release stands extended till the next date of listing.
Oblige.
Item number 17.
Okay.
Milord, I filed one application before this honorable court about the rejection of the petition under section 37 of the Arbitration and Conciliation Act. Because Your Honor, the appeal will not lie against the orders of the Lok Adalat section. They have filed the Lok Adalat. I mean to say, Your Honor, can you see the page numbers? Page number 141 of the appeal, Your Honor. This is the order passed by the Bomdila court. And I'm referring the page number 149. Because here, you know, the respondent filed an application to reject the petition. Because they have filed belatedly without following section 34(3) of the Arbitration and Conciliation Act. Thereby, it is completely barred by law of limitation. And also, Your Honor, prior to that, they wantonly filed one case at Siliguri, Your Honor, which is not having jurisdiction. The court is not having any jurisdiction. So kindly see page number 101, Your Honor. 101.
Yes.
Yes, in the please kindly see, Your Honor, the ordered part, my lord. The application under Order 7, Rule 10 of CPC, dated 6/11/24 is allowed on context without costs. Accordingly, let the main application under Section 34 of the Arbitration and Conciliation be returned to the applicant, opposite party with a liberty to file either at Bomdila or Shillong. The case stands disposed of accordingly. After that, they have to file the matter at Bomdila within the time. But the petitioner here in Your Honor filed belatedly at Bomdila court, and again the respondent filed one more application, Your Honor, there to return the Section 34 application which was filed belatedly. That is the order of the court, Your Honor, 141, page number 141. It starts from page 141, Your Honor, ends with 149. Paras 17, 18, 19 are relevant, Your Honor. They filed it to Siliguri Court, Your Honor, 3 months, 27 days after. So the file was written on 21/25. They have not taken the file, Your Honor, from the court, Siliguri Court. Afresh, they have filed the matter on 12/3/2025. Thereby, they lost the valid period, Your Honor, under limitation 34(3). They have to file within 3 days from the date of return of the file. But they filed after 35 days. And Your Honor also very well aware, the orders passed by the court which is not having any jurisdiction is non-est in the eye of law. So, the same contest was taken before the Bomdila court by the respondent here in Your Honor.
But this application at Bomdila was filed when?
That is on 12/3, Your Honor. Initially, they filed on 27/2, Your Honor, 27/2/25. On the same day, it has taken back, and the court has granted 5 days time. The petitioner herein has taken back the file on the same day. And I'll show that order also, Your Honor.
Just a moment. When the Siliguri court returned, it did not give a date.
No, Siliguri court written is date is there on the top, Your Honor.
No. The date within which it can be filed is not given.
Yeah, it was not given. Then automatically within the limitation they have to do it. Suppose, Your Honor, in a pro note suit, limitation is 3 years period. If you spend 2 years in a wrong court, you have 1 more year also there to file in other court. That is
on filing of a suit. But this will not apply when it is returned. Then you get the benefit of Section 14.
Yes, Your Honor. They have not filed Section 14 also.
No, for 14, there's a judicial pronouncement even by this court. We have held that for Section 14, you don't have to file an application. There must be a reason assigned in the application itself that would itself be sufficient.
That has to be mentioned in the prayer portion or somewhere, Your Honor, in the suit.
Yes, has to be mentioned.
Yes, they have not mentioned. Wantonly, they have mentioned the date of return. This court has written the file on 21/25, Your Honor. On the top, date is there.
Yes.
Actually, they have filed 3 months, 27 days after. They already filed, Your Honor, Section 34(3) of the Limitation Act, delay condonation petition in the Siliguri court. The Siliguri court also allowed the delay condonation petition, but the court has no power to allow it also. So 3 months, 27 days was spent there. Then they have time, 3 days time only, because the Act says 34(3), not thereafter. So 3 months, 27 days plus 3 days means they have to file on by 23. By 23/1/25, they have to file at Bhumdela Court to save the limitation. Whereas they file on 27/2/25. That is 35 days after. And the court has taken the case, maybe lack of knowledge or something, Your Honor. So kindly see the page number 102, Your Honor. Same booklet. 102, 102, Your Honor. As prayed by the Land Council, Mr. Kamal Devan, the judgment debtor is allowed to withdraw this appeal with a liberty to file afresh within 5 days from today. But this is also wrong, Your Honor, because by 27/2/25, the limitation was already over. After that, Your Honor, kindly see the order, Your Honor, Bhumdela Court Order 141.
Yes.
Para 17, Your Honor, page number 148. The judgment referred to here above clearly goes to show that order passed by the court lacking in jurisdiction is honest and void ab initio. Therefore, the order dated 21/9/25, whereby the Land Commercial Court Siliguri had granted an application under Section 34 arbitration and conciliation and is found to be honest and void ab initio. Accordingly, the argument of Messrs. Devan that the same may be treated as extension of time for filing application afresh in this court is not at all found to be sustainable. Therefore, in the absence of any application of Section 14 of limitation, I find no reason to exclude the time taken in the proceedings in the wrong court at Siliguri. Accordingly, the application filed by the opposite party under Section 34 of the Conciliation Act being barred by its subsection 3 is not found to be maintainable in all respects. In view of the foregoing discussions, the interlocutory application stands allowed and disposed of. Consequently, the delayed application filed by the opposite parties under Section 34 arbitration conciliation being registered as a civil so hereby rejected. What is taken after that, Your Honor? The court has taken up the EP proceedings because the said EP was filed prior to filing of Section 34 application, Your Honor. And kindly refer to the next page, Your Honor, very next page.
Seven.
151, Your Honor, that is Annexure 7. So now both parties, after the rejection, this is important, Your Honor, after rejection, both parties goes to the Lok Adalat for settling their dispute. And in the settlement, Your Honor, the respondent has agreed to pay the petitioner herein is agreed to pay the entire amount with interest. The dispute between the parties having been referred to for a determination to the Lok Adalat and the parties having settled the matter, the following award is passed in terms of the settlement. The Union of India represented by so-and-so, Mr. So-and-so, GE Tanga agreed to pay. So he represented that GE Tanga agreed to pay the awarded amount of so-and-so with interest, only along with interest, and as mentioned in the award within a period of 5 months from today. This is on 13/5. I mean to say 13 September 25. They came forward and they agreed before the Lok Adalat that they are going to pay the amount. They have signed, their advocates also signed, everybody signed. Now the question for consideration is that, Your Honor, the respondent is contesting.
What is the date of this order?
Order is on
13
the last
September.
side, 13/9/25.
Yes.
So the question before this honorable court is, by the petitioner, Your Honor, the person who has signed here is not competent person to sign. So what made them to depute, Your Honor? He is the officials of the respondent. He was deputed to sign on the award. and he signed. There he did not raise any objection before signing, or the advocate also did not object anything. They have simply signed and they have consumed 2 to 3 months time and filed here. The question is, Your Honor, once the party with his willful act waived his rights under the Arbitration and Conciliation Act and approached the forum Legal Service Authority for award, can he go back, Your Honor? Am I clear, Your Honor?
But if it is without authority, then it would be no award at all.
This is the award, Your Honor, award given by the Lok Adalat.
No, but if the person has no authority,
No, that has to, the same steps has to be taken before the Lok Adalat. What prevented them? I have no authority, but there is no, Your Honor, rightly question, whether they have filed any document before this court. The gentleman who has signed there has no authority for which they have to file a document here also in the appeal. They have not filed so. Now the mute question before the court is, suppose, Your Honor, any fraud is taken place in this? No, voluntarily done by the parties, and there is no irregularities committed by the court. Non-information is because of the party, and still we do not know. So, Your Honor, once a Lok Adalat award is passed, the questioning must be under Article 226 and 227 of the Constitution of India by way of writ, but not by way of appeal. I am placing 3 judgments, Your Honor, in this regard. All the 3 judgments you give it. This is Dilip Mehta and Rakesh Gupta, Your Honor. That page number. Kindly see para 9, Your Honor. Para 9 of the judgment. You want copy? I do copy. Yeah, I have copies. Yeah, let me give the copies. No problem. While referring the Supreme Court judgment, para 9, Your Honor, this court has, in a series of decisions, explained the consequences of the statutory finality in state of Punjab vs. Jalar Singh. It was held that where an award is made by a Lok Adalat in terms of a settlement between the parties, this is important. In terms of the between the parties, it is final and binding and executable as a decree, and that no appeal lies against it. It was further held that any challenge to such an award must be brought before the High Court in proceedings under Article 26, 27, 227 of Constitution of India, and only on limited grounds such as lack of consent, jurisdictional error or fraud. This is important. There they have given consent. They have only deployed their person to give consent for the award. In Bhargavi Construction versus Kottakapu Mutyam Reddy, this court applies the same principle to a civil suit which sought to impeach a Lok Adalat award, and held that a civil suit to set aside such an award is not maintainable, and that only proper remedy is writ petition before the High Court. Even para 10 also, Your Honor. Para 10 also same. And another judgment, Your Honor, SAM Syed Ali Akbar versus District Legal Service Authority. Para 24, Your Honor, I am referring. Examination of the provisions reveals that if a reference is made with the consent of the parties to the Lok Adalat, para 24, Your Honor, to the Lok Adalat to examine an issue in a pending suit, the Lok Adalat must formulate its own procedure and try to bring about an amicable settlement between the parties. If a settlement is reached, an award may be passed. Such an award is signed by both the parties to indicate their acceptance to abide with such award, and thereafter they cannot file an appeal against the said award. It is binding on them. It is also seen that the Lok Adalat stipulates following so and so. The parties have to be given an opportunity of being heard. They must be heard. Therefore, when a settlement or compromise is reached, and when an award is passed in terms of settlement or compromise, the parties cannot turn around and claim that the award was on the basis of a fraud played by one of the parties. In effect, the award of Lok Adalat is binding on the parties to the suit. They had accepted reference of the issues before the Lok Adalat. They had participated in the proceedings. They had entered into a settlement of a compromise. They had accepted to the terms of such settlement or compromise. They had held out a promise to the other party that they would abide by the terms of the settlement or compromise. They had then consented for an award to be passed in terms of the settlement or compromise. They had also signed the award. All the ingredients were fulfilled in my matter also. However, and 27 I am reading. However, an award by the Lok Adalat is passed based on a settlement or compromise entered into by the parties to the suit voluntarily and with the sanction of court. The signatories to the award are not only the plaintiff and defendant, but also the presiding officer, members of the Lok Adalat. All of them agree that a settlement or compromise had been reached and that the terms of the settlement and compromise as written down are the terms and settlement of compromise agreement between the parties. Thus, the award is binding on all of them. This position is clear. There can be no doubt about it. No party can file an appeal against the terms since they are themselves parties to the award. Kindly see the para 32 of the next judgment, Your Honor. This is K. Srinivasappa.
Yes.
In view of the aforesaid discussion, we shall.
Paragraph?
32, Your Honor.
Yes.
In view of the aforesaid discussion, we shall now consider the facts of the present case, the details as to the terms of the compromise as well as contentions raised at the bar have been narrated above. On a consideration of the same, the following aspects would emerge. The Lok Adalat, in its award dated so and so, recorded the parties had admitted that the contents of the compromise petition were true and correct. After the terms thereof had been read over and explained to them in Kannada language.
You are reading which paragraph? 32.
32.
32 starts with in Jagdish Ahuja.
Maybe.
So we have a copy of SEPCO Electric Power Corporation.
Yeah, K. Srinivasappa, sir. That is the judgment.
This is SEPCO Electric.
No.
Just show you this.
Like that. Then you give it to the. You have no copy with you? Just one minute. Thank you.
Yes.
In view of the aforesaid discussion, we shall now consider the facts of the present case. The details as to the terms of the compromise as well as the conditions raised at the bar have been narrated above. On a consideration of the same, the following aspects could emerge. The Lok Adalat in its award dated 7th July 12 recorded that the parties had admitted the contents of the compromise petition were true and correct. After the terms thereof had been read over and explained to the Kannada Further, it was also noted that the compromise was entered into by the plaintiff on behalf of and for the benefit of his minor children. In order to protect their share, the same was allowed by the Lok Adalat on recognizing the terms of compromise would protect the interest plaintiff number one, minor children. There is no objection raised on behalf of the plaintiff number one in the instant case. Here also there is no objection, Your Honor. The Lok Adalat in its order dated 27th April 23 rejected the allegation of fraud raised by the plaintiff number 4 to 6 against the defendant and recorded that the plaintiff 4 to 6 had offered no explanation as to why no objection was raised by any of them on 7th July 12 before the Lok Adalat. It was further observed that plaintiff number 4 to 6 could not, after having accepted huge sums of money in terms of compromise, rescind from the terms of thereof. So the point is, Your Honor, why they have not objected? Being a central government organization, they deputed one person to enter into a terms with the party, and they have not, the person who attended simply signed without any objection. The other thing is that, Your Honor, once the Lok Adalat award is passed, you are willing or accepting the Lok Adalat, that is Legal Service Authority Act. Once the act is emerged to Arbitration Conciliation Act 2, Legal Service Authority Act, how Section 37 will lie here? 37 is only appeal against the order of the Boomdela Court. In the same Boomdela Court, they have appeared before the Legal Service Authority Act and agreed for this. So automatically law was changed. So they have no right to file any Section 37 application here, Your Honor. That too, the period of limitation was already over long back. As such, Your Honor, at this stage itself, Your Honor, reject the Section 37 application.
Yes, Mr. Gato.
Lordship has already get the details of the case. Only two grounds, we are before your Lordship on the two grounds. Firstly, the Section 14 has not been taken into consideration. Admittedly, that they went to the wrong forum, and that part is not considered. The another limb of submission is we have taken in this ground is regarding the settlement of the matters outside the court in the Lok Adalat. As it has been clearly mentioned in my petition on affidavit, executive assistant engineer is not at all permissible under the law. Financial delegation is also not there. It is the executive engineer who has to be the represent this. So therefore, the representative of the chief engineer only. Only chief engineer is the authorized to the settle. But this assistant engineer was only deputed to represent to see the court proceedings, not authorized to settle the matter. The financial delegation is not quite apart from other the service rules. There is no the financial delegation in respect of this assistant engineer. And what happened in this matter, particularly when the matter was on 9, matter was disposed of by the court, Planet Trial Court, by order dated 9 September 2025. Impugn order. Thereafter, matter was again sent to the Lok Adalat. Assistant engineer who is not at all having financial jurisdiction and the authority just went to see the proceedings. And he has been made understood. Of course, admittedly, to that extent, it is difficult to show your Lordship that without knowing anything, this officer has put his signature. Now the question is, without financial such authority, delegation, it is a central government work. Such the officer who is not at all authorized to sign and settle, he cannot. But he has been made to the signature on the point. If Lordship kindly peruse the impugn, which I have impugned at page number 150 of my the petition, It has been clearly mentioned, Union of India, judgment debtor. Union of India,
You're referring to which page?
I'm referring page number 150 of my petition,
150, yes.
Yes, Malad. Award, dispute between, it is Union of India, I'm reading from the second paragraph.
Yes.
Union of India, judgment debtor, represented by the Zakir Hussain, assistant engineer, military engineering, he is not at all authorized, Union of India has to be represented by such a higher officer, Just he went to the admittedly that proceedings just to see the proceeding only, not beyond that, Therefore, this is not an the award. The award which has not been from the very might have an issue, it cannot be the parties, to my limited understanding, whatever the senior referred, the judgment of various high court and the Supreme Court is particularly in respect when the person authorized to settle the matter, not by the delegates and not by the other officers, not by the parties, other than the truly representing the respective parties, But here, in our case, it is quite different, as because this assistant engineer is not at all authorized to represent Union of India, First, my limb of submission. Now, a second limb of submission. My first limb of submission, regarding section 14, it has been clearly mentioned in my ground, ground number 1, 2, 3, is in respect of that particular But we have not taken much ground, only limited to ground
First judgment.
4, where it that specific has been gave ground number 1, 2, and 3 regarding that section 14 So therefore, in the so it is arbitration proceedings, In the trial court, the law is not always required to be pleaded, This is the well-settled position of law. Even if law is not pleaded, only the fact has to be mentioned. That fact has already been reflected in the my application under section 34, wherein the wrong forum, they went to the wrong forum, That is specifically mentioned. But my submission is all the laws are not required to be pleaded before the trial court, but it is the settled position, Now, on this issue, there is a already settled position of law. That law of limitation, the very basic purpose of the underlying principles of the section 14 is given. So that is not required to be pleaded, and that cannot be fluted also by the trial court. That has
Section
been
14 not required to be pleaded.
Malad.
Section 14 you say is not required to be pleaded.
My limited understanding is it is a law, settled law. It is a law. In the pleadings, everything is not required to be pleaded. Of course, that particular averment is not made, regarding wrong forum, The very much fact of the case has been reflected in my application, section 34, wherein the applicant went to the other wrong forum, So therefore, this section 14 covers from the facts of my case, So therefore, it is protected under section 14.
Mr. Raju, for the applicant, he is not even raising those issues. He's saying about the maintainability, that once there's a local award, the appeal would not be maintainable. So nothing to do with section 14 or any other provision of law relatable to arbitration or limitation. It says that once it's an arbitral award, the award in a Lok Adalat, then
that
it will
point,
not be maintainable.
that part, I have already made submission on the past limb, it is admittedly deems to be settled by the officers who is not at all authorized to settle, if judgments of the various high courts and the Supreme Court is, if it is relied upon, this is in respect of the persons who authorized to represent, But in my case, why I am distinguished is, it is a case where the authority is not authorized to, the persons who represent on behalf of the Union of India is not at all authorized to represent Union of India, Authorized person is not below the rank of chief engineer, To that extent, it is admittedly, the judgment relied by my senior friend is not covered. Yes, with this admitted position, if the settlement made in the Lok Adalat, it is decree, amount to be decree, that part we are, considered. However, only this thing, guys, is, as I pointed out, that unauthorized person, So therefore, in arbitration, proceedings, may I rely upon one judgment of the Honorable Supreme Court, wherein it has been clearly mentioned,
No problem, I know it.
Yes.
Proceed.
2008-7 SSC, page 169, It is on limitation, basically,
169.
169. 2008-7 SSC 169. The relevant arise page number 181, para 21, para 21, para 27, 22 also, 27 and 28,
Para 20.
to 21, 22, 27,
21,
and 28.
22, 27, 28.
It is basically on limitation, law, section 30, section 14 of the law of limitation. And in same similar. This is the latest judgment on this subject. This is online copy,
Just a moment.
Sure. Kirpal Singh.
Just a moment. Yes.
This is the of Honorable Supreme Court, Kirpal Singh versus Government of India, New Delhi, so and so, this straight away I'll take your lordships to para 5, wherein my lord, exactly this is the similar case wherein my lord, such the case was my lord, held. May I read, my lord? Section para 5, my lord. The district judge took up the application under section 34 of the Act, and by his order dated 16 May 2012, dismissed the same on the ground that it is barred by limitation as determined by this court in the case of Union of India versus the Popular Construction. The appeal under section 37 of the Arbitration Act was also dismissed by the order impugned before us. Mr. So-and-so, my lord, I'll skip this part, my lord. This is the same case, my lord. Para, my lord, 10, my lord. I'll skip, my lord, the rest of the... To my understanding, my lord, this is this exact and the similar the case relating to our present case, my lord. Para 10, my lord. I'm reading, my lord. We may hasten to add that when the substantive remedies under section 34 and the N/O 37 of the Arbitration Act are by their very nature limited in their scope due to statutory prescriptions. It is necessary to interpret the limitations provisions liberally, or else even the limited window to challenge an arbitral award will be lost. The remedies under section 34 and the 37 are precious. The courts of law will keep in mind the need to secure and protect such a remedy while calculating the period of limitations for invoking this jurisdiction. Applying section 14 of the Limitation Act, we hold that there is sufficient cause for excluding the period, the commencing from so-and-so, madam, in view of the fact that this period is excluded, madam. The appellant will be entitled to the statutory remedy under section 34 of the Act. In view of the above, we allow the appeals, set aside the impugned judgment and set aside the judgment and order passed by the High Court in FAO numbers so-and-so. Madam, there are madam, on so-and-so, and also the order of the district judge, the Jalandhar, dated 16 May, Malad, this is the impugned order, Malad basically went to the Malad Honorable High Court, and restore the section 34 petition in arbitration number so-and-so to its original number, Malad. We further direct the district judge, Jalandhar, to issue notice to all the parties and hear them and decide the parties as per law. Malad, exactly this is the period which we are, Malad, praying before your lordship for remanding of the matter to hear the at least, Malad, the on its merit, Malad. So therefore, Malad, my submission is, Malad, this is a pit case wherein, Malad, this matter can be Malad, remanded back to the trial court to hear the, Malad, the application under section 34 by restoring the, Malad, the application. And that, Malad, another, Malad, the submission which I have made, Malad, regarding the settlement order, Malad, that point, Malad, to that extent, Malad, I have no any authority on that issue, Malad.
Small representation. This is not because of section 14. They have kindly see the para page 121, Your Honor. Only 10 minutes, Your Honor, not more than that. Page 121.
Yes.
Subsequently, after appearing before the Siliguri court, the petitioner received the copies filed by the respondent herein. By going through the pleadings, it could be understood that the respondent herein had filed the petition under section 34 along with the delay condonation petition under section 34(3) Act. As per the petition, section 34(3) of the Act, filed by the respondent herein for delay condonation, the copy of the award dated 20/10/23 was received by the respondent herein after on 23/10/23. The land arbitrator by its email dated 21/10/23, that is Saturday, sent the award copy. The respondent has acknowledged about the award copy either on Saturday or Monday on 23/10/23. Finally, the respondent herein considered the date of receipt as a 23/10/23 and filed the delay condonation petition. The respondent herein filed the application under section 34 on 27/2/24. Therefore, on record itself, it could be found that the respondent herein has filed the application under section 34 of the Act 96 after 3 months, 35 days from the date of receipt of the award, that is 20/10/23, which is beyond limitation. As per section 34 of the Act 96, the party who intended to challenge the award can do so within 3 months from the date of the receipt of the award. So that is the first point, Your Honor. The second point to be considered is yes, para 12, Your Honor, page 124. Para 12, page 124. The respondent herein has not filed any documentary proof to show that the respondent herein has received the award copy on 31/10/23. Their other contest is they have received the award on 31/10/23. Even assuming without conceding the respondent herein has received the award on 31/10/23 as alleged by the respondent herein, the respondent herein has to file the case on or before 31/1/24 by considering the 3 months period, whereas the respondent herein filed the section 34 application on 27/2/24. Therefore, the respondent herein has not filed the case within the limitation period and filed the extended period of, that is 30 days, as provided under section 34(3) of the Act. Considering the date of filing at Siliguri Court on 27/2/24, the limitation period remaining to the party is only 3 days because they have filed 3 months, 27 days after. So 3 days limitation is there. That is up to 29/2/24 and 1/3/24. Therefore, it is the mandatory duty of the respondent herein to file delay condonation petition under section 34(3) of the Act 96. The Honorable Siliguri Court, by its order dated 21/25, returned the file, and thereafter the respondent herein has to file the case before the Honorable Court on 23/1/25. So that whatever time consumed, I have not taken, Your Honor. To save the limitation, that too after filing a delay condonation petition 34(3) of the Act 96, and also file a separate application on section 14 of the limitation to condone the delay in pursuing the matter in having no jurisdiction. The respondent herein has not followed any procedure as contemplated under law, simply filed the case before the court on 12/3/25. Had this court given its kind consideration and condoned the delay in pursuing the matter by the respondent herein, in the court having no jurisdiction, even in spite of not filing the application under section 14 of the Act, I have clearly mentioned, from 27/2/22 to 21/25, still the matter would be barred by law of limitation. As such, the filing of the case before this Honorable Court is 12/3/25 with a delay of 48 days itself, barred by law of limitation. As such, this court has every right to reject the petition under Article Rule 7 of the Article 7, Rule 11, Your Honor, of CPC. So the very limitation itself barred. I'm not bothering about the section 14 application or anything, because whatever time they pursued in the wrong court, even that is removed, even then also there is a delay in filing section 34. And the other thing is that, Your Honor, my friend has represented that CE has to sign and other people have no right to sign on the settlement. If it is so, Your Honor, who has signed the appeal before the court? Whether CE has signed the appeal before the court? page, 116 page, that's what. You kindly refer to page 116, Your Honor, of the appeal. 116. Yes. Yes. Mr. Mohan Singh Yadav, 37 EE, designation as EE, garage and engineer, GE, Tanga, so and so, he has signed. And this award also, Your Honor, kindly see the page number 150. 150, Your Honor, page number 150. Para 2. The gentleman has signed on behalf of GE, the Union of India, represented by so and so Military Engineering Service, comma, there is a comma, GE Tanga agreed to pay the awarded amount. So when GE Tanga has the right to file the case here, then the payment can be done by the GE Tanga. So therefore, entire contest of the petitioner here in Your Honor is wrong, because this was not signed by the chief engineer. If chief engineer is only having power to do it. First of all, the bar of limitation under 34(3), Your Honor, that is complete bar. Kindly see the CPC, Your Honor. Order 7, Rule 11. Order 7, Rule 11, D. Where the suit appears from the statement in the plaint to be barred by any law. So it is barred by any law. That means Pre-Litigation Act did not allow the party to file the case here. And also 96(3), Your Honor. Section 96(3) also states that no appeal shall lie except a question of law. No. 3. No appeal shall lie from the decree passed by the court with the consent of the parties. So the remedy available to the party only writ, or if at all fundamental mistakes committed by the irregularities committed by the court, then they have to go and reopen there itself, not here.
Yes, also. No, secretary. Oh, yes. No, it's okay. I did not see him. But Mr. S.V.K. Raju, learned counsel for the applicant, as well as Mr. M. Kato, learned PhD, appearing for the respondents. Arguments are concluded or reserved.
He has already recorded my name.
Leave the placement.
Your Vakalatma is not there on record.
Yes, sir. I filed my wakalat also.
It's not reflected here.
And
Yes. We have the.
No, it's okay, but.
Name is not reflected.
Huh.
Vakalatnama is here.
I think on 6th May I filed the wakalat.
Ah, yes, it's available.
Yes, you Krishnan also.
Okay, available.
SB. They are right. It's on the
Okay.
Yep.
You write it now.
Item number 18.
RAJ.
Just one, call someone. I'll take a break and come back.
Lordship,
Just
Mayor.
take us some time. I have to take a break and come back. I have to take a break and come back. Oh, sure.
I beg.
Item number 18.
Yes, where is he gone?
I don't know.
My lordship.
18.
Yes, you have not taken steps. We'll have to dismiss your application.
Lordship, already respondent has complied these orders.
Has complied with the order.
Yes, that's
Okay, your name?
B. Sibo. B. Sibo.
Mr. B. Sibo, learned counsel for the petitioner, submits that as per instructions received by him, or the order dated 6/8/2024, passed by this court in WPC 575 of 2023 has been complied with. So next, accordingly, the matter stands closed on satisfactory.
Olas.
Item number 19.
Please, your lordship. The pleadings are completed, lordship. The matter may be fixed for admission hearing.
Your name?
M. Bori, lordship.
Ms. M. Bori, learned counsel for the petitioner, submits that the matters pleadings have been exchanged and the matter is ready for hearing. Accordingly, it's in the admission column on
Lordship, it may be fixed on 3rd of July, lordship. 3rd of July.
3rd of July, we can't give. It's just before vacation. It goes after vacation.
20 July.
20 July. Okay.
Lordship, there is also an interim order. It may be continued.
Interim order passed today stands extended to the next date of this day.
Obliged.
Item number 20.
Lordship, government not yet to file affairs in opposition.
My lordship, we need some more time, my lordship.
Pending for over a year. Mr. B. Sibol, and counsel for the petitioner. Steve Angmol, and government advocate, prays for some more time to file affidavit in opposition with the matter. Next para. This writ petition was filed on 9/6/2025. So initially, the court, by order dated 10/6/2025, required the learned government advocate to obtain instructions, and thereafter, by order dated 17/6/2025, while issuing notice of the interim order was passed not to give effect to the impugn order dated 16/5/2025. First off, the interim order has been extended from time to time. Right. However, the state respondents have, however, none of the respondents have filed an affidavit in opposition. Next para. The respondents are put to notice that In the event no affidavit is forthcoming, it's not filed within, at least within 2 days from the date of, 2 days prior to the next date of listing, the court would be inclined to take recourse to the doctrine of non-traverse and presume that the respondents have admitted the claim of the petitioner. And appropriate orders will be passed. Next para. The learned government advocate is at liberty to send a download copy of this order to the concerned respondents. Next para, list on due date after vacation.
22nd July.
Lordship, entry may be continued.
Interim order extended.
July. Item number 21 and 22.
It will come to admission column.
Lordship?
Readings have been exchanged. It will come to admission column.
Yes.
What is this IA for?
IA is for implement.
Or impediment?
Yes, Lordship.
Of whom?
Of me, the power of attorney. Lordship, there is an writ petition filed by the TM Enterprises, wherein the pending liabilities has been claimed by the writ petitioner there without the information, without cancelling the prior power of attorney, which has been given in my favor, in my name. Order में ना? Lordship, this was supposed to be listed on admission hearing, but in the course list, in the orders, it has been listed. Twenty-one. Wait. 21 में हम implement के लिए process कर रहे हैं.
But in view of the objection, we can't permit you to do it. He is the principal, he has cancelled your agreement. You'll have to go to the civil court.
Yes. Yes, Lordship, we are praying for that only, Lordship. Lordship, they have filed a writ petition here for pending liabilities. However, I have not been made party in this writ petition, whereas I was the one who executed all the work here.
No, but that is an interstate dispute between you two.
Yes, Lord.
The writ petitioner, he has filed an objection saying that the power attorney has been cancelled. Whether it is cancelled or not, that's for the civil court to decide. But in the writ petition,
yes,
you
Lordship,
can't be made a party as an applicant. Who is this applicant? Techi
Talita.
You can't be impeded.
Lordship, if I am not being impleaded here, then if the writ petition is allowed, then I'll be.
For that you have to remedy to civil court. The High Court will not entertain that dispute. Their affidavit is there, they're cancelling your power attorney.
Lordship, I have not received any kind of notice or any kind of information about that.
Objection, you have received that.
Yes, Your Lordship.
Then that's not under challenge.
Lordship,
You see, you have got it now. Earlier, you may not have received it.
I have received their affidavit in opposition, Lordship.
You see, all the documents are annexed. The High Court cannot entertain this private dispute between you two.
Yes, Your Honor. Yes, my lord. So it ought to be challenged the cancellation order before the appropriate forum. It is in civil court.
But herein, Lordship, if we see, then the Lordship, I should be made the party here because
You can't.
Lordship,
You can't be implemented as a party. We'll take it up day after tomorrow.
Day after on Monday.
day after tomorrow.
Friday, I will be out of station, my lord.
Okay, Monday then. We'll give
So
it
may-
an opportunity.
Okay.
So
Lordship.
maybe Monday.
Okay. In this IA, you say that but Miss
D. Riba,
D. Rivardhan and counsel for the applicant. And also heard Mr. N. Tajil and counsel for the opposite party number 1 and Ms. P. Pangul and the government advocate for the opposite parties number 2 to 5. Next,
Only respondent number 3.
Huh?
Respondent number 3, Your Lordship. Food and
There
civil.
is the opposite party.
Yes, Your Lord. For food and civil.
So 2, 3 and 4.
Yes.
No, 3, 4 and 5. Correct. 2, 3, 4 and 5.
4 and 5.
So will be 2.
Yeah,
Food civil supplies.
2 and 3, Your Lordship.
3.
Food and
Who is
civil
deputy commissioner? 5 is district food supply officer.
3 and 4 will represent by 3 only.
3 only, Your Lordship.
2 and the 4. Standing council.
Standing council.
Environmental on standing council area.
Who?
T. Jammu.
T. Jammu.
But it's not here. So 2 and 4 is Mr. Jammu.
Yes.
Okay, then legislate 3 and 4. None appears on call for respondent, but opposite parties number 2 and 5. Next para. In the affidavit in opposition filed in respect of this application, the petition, the opposite party number 1 has taken a plea that not only the agreement but the power of attorney based on which the applicant has filed this application has been cancelled. Next, accordingly, the land counsel for the petition applicant seeks some time to address the court. So matter stands adjourned today, list on Monday. In the writ petition, say that all sides are represented as the connected interrogatory application for impleadment has been deferred, list this matter on Monday would be
15.
15th.
Monday, 10th, yeah.
15 a.m.
Okay. Yes, Your Lordship.
Item number 23.
My lord.
Okay.
I'm not sure.
So ready civil service.
Yes, ma'am.
None appears and call for the petitioner. However, Mr. Wangbo, the government advocate, is for the respondent numbers
1, 2, and 3. ma'am.
1, 2, and 3 is present. Next para. As for office note dated 9/6/2026, AD card in respect of respondent number 4 has been received. First of none appears on call for respondent number 4. Next para. List in the admission column. I'll give a date after 2 weeks.
24 June. Item number 24.
May I please, my lord? My lord, this application filed for recalling of this dismissal order, my lord. Annexure 1, page number 10. My lord, on 25/5/2025, my lord, this matter was listed and on call, the matter was dismissed for non-prosecution, my lord. So, in this case, I am the counsel, and from 15/5/2025 to 25 till 25, I was on the letter of absence, my lord. So I was out of station. So my name is reflected in the court list also, my lord. Kindly come to page number 17. Page number 17.
Restore it. Thank you. Restoring this. His name is there in the cost list.
Yes,
Yes.
sir.
Got Mr. N. Tajal and counsel for the petitioner.
My lord, I'm there for respondent 1 to 3 in this case, my lord.
Okay. Respondent 1, 2, and 3. Your name?
Mr. T. Marngar, my lord.
P.
On behalf of T. Marngar for Nitin Khera.
Mr. P. Manan, counsel for the respondent was 1, 2, and 3. Appears to video conferencing. Ms. P. Pangulan, government advocate, appears for respondent 4 and 5.
Only 5, Your Lordship.
Only 5. Who is for 4?
On behalf of El Farme, T. Tagam.
Okay, just record his name for respondent 4. Present. We are allowing this application. His name is there in the
My
list.
lord, my lord.
By filing this this miscellaneous petition, the applicant who is the petitioner who is also the petitioner in WBC 567 AP of 2023 has prayed for recalling of the order dated 25/5/2026 passed by this court in WBC 567 of 2023, by which the said writ petition was dismissed for non-prosecution. Next para. The learned counsel for the petitioner has referred to the cause list of this court dated 25/5/2026. And it is submitted that in the letter of absence, comma, his name is reflected in the said column for being on leave from 15/5/2026 to 25/5/2026. Full stop. Next paragraph, therefore, comma, the petitioner has been able to show a good cause for non-appearance of the learned counsel for the petitioner on 25/5/2026, comma, when WPC 567 AP of 2023 were dismissed, as the name of the learned counsel is reflected in the letter of absence column. Full stop. Having heard the learned counsel for the respondents, appearing respondents, comma, the prayer stands allowed. The order dated 25/5/2026, by which the writ petition was dismissed, is recalled. So this application stands disposed of. And just pass it to a further order. Accordingly, the registry shall treat the proceedings of WPC 567 AP of 2023 to have been restored to file. Full stop. And list this said writ petition on 21. Says the date. You just pass this order in writ petition from this, that in view of order passed today, heard so and so, in view of order passed today in MCWP number 3 of AP of 2026, by which this writ petition has been restored to file. The registry shall restore this writ petition to file. Next paragraph, list on. Yes.
21 Sunday. 21 Sunday.
30.
23.
30.
This will be last week. This is a
29.
29.
My lord, can it be after vacation? 29 it be.
after vacation.
Then 27, 20 July. 20 July.
All right. All right. 20 July.
20 July.
Okay.
It's all right. All right.
Okay, I don't think I have the energy to take up more matters. I'll have to take a call.
There was one unlisted withdrawn. Should I call that one unlisted matter to be disposed of? There the unlisted item number 31 to 33.
May I please, my lord? My lord, I would like to withdraw my writ petition with liberty, my lord.
You'll have to tell us if you want the liberty, you'll have to tell us why you need the liberty.
Yes, my lord.
If you want a leave to come again, you'll have to tell us why.
My lord, this is the matter of legality and validity of the tender process, my lord.
Yes.
And my lord, it is
You have to tell us what is the defect for which you wanted to withdraw and then file it again.
in the last occasion, this honorable court has apprised to respondent number 3 to file an affidavit and respondent for, and accordingly, respondent number 3 has already filed affidavit, my lord.
See, the court would never advise. We can direct, but we will not advise somebody to file an affidavit. There's no order directing anybody to file an affidavit.
In my lord,
None of the three petitions there is any direction.
my lord, in order that dated 29/04/2026, my lord.
29?
29/06/2024. 29/04/2026.
$29,400.
Yes, my lord.
$29,400, Mr. Ratan paid for time and he was granted time to file affidavit. So for that, you can't withdraw the writ petition.
Yes, sir, Lordship. We have filed, Your Lordship.
He have already filed accordingly, my lord. Respondent number 3 has already filed.
So that's okay, but you wanted leave to withdraw and to file again. You'll have to tell us reasons. We can allow you to withdraw the writ petition, but not leave to file again. You'll have to tell us what is the defect, why you want to withdraw.
My lord, this matter has already filed accordingly. Respondent number 3 has already filed affidavit.
It is okay. If
Yes,
you are, you see, at your request, we are issued notice.
yes, ma'am.
They'll come and file a reply. There's nothing strange about it. But why you want to withdraw? And then file again?
Yes, my lord. In affidavit, my lord, respondent number 3 has already approval the tender authority already given in affidavit, my lord.
Then you don't need a reply, don't need a leave to file again. If anything happens, it will be a different cause of action. Yes, what is the affidavit you have filed?
Yes, sir. Yes. Video करना चाहते हैं बताओ ना अच्छे से
Oh, जना.
वीडियो भी करना चाहते हैं बताओ ना अच्छे से
हाँ. Sorry, my lord. My lord, this matter is for withdraw for the grievances. The grievances of the petitioner was already addressed by the respondent number 3. So, my lord,
Okay.
in the affidavit.
Has to be because. Okay, your name?
K. Moses, my lord.
Upon instructions, Mr. K. Moses, the learned counsel for the petitioner, has submitted that that by filing of the affidavit in opposition by respondent number 3, the grievances of the petitioner has been addressed. So accordingly, he has instructions to withdraw the writ petition. Stop. Prayer is allowed. The matter is dismissed on withdrawal. Of all these matters. And then there is an IA.
Deeply aware, madam.
IA, you will say that in view of the order passed today in this connected WPC 130 AP of 2024, this matter stands closed. Yes.
May I please the Lordship? I beg to mention item number 30, Lordship. It may be take up tomorrow, Lordship.
Tomorrow it will not be possible. Tomorrow it will not be possible. It's a division bench day. Fix it next week.
Next week is Lordship, I am not possible, Lordship. Earlier occasion, I have also come from Guwahati 4, 6.
No, we understand, but tomorrow is not possible. You have already listed a matter for hearing, and tomorrow is a division bench. You will not have time.
Lordship, July, Lordship.
Suggested date will fix it on that day.
Lordship is 20 July, Lordship, after vacation.
Twenty.
Yes, 20 is possible.
So A. Barbar and counsel for the petitioner is and the learned government advocate are present. So, as it is already 5:55 PM, the matter cannot be taken up for hearing. List again on 27/2026.
May I please, Your Lordship, I'm like to mention item number 26 to 27, it's for implement, Your Lordship. Two parties, maybe fixed tomorrow, Your Lordship. It's a contempt case, Your Lordship.
Where is that? See? Your notice is defective. You see, you have wrongly understood this order. The order dated 3/2/2026
Yes, Lordship.
means that you see, when is the contempt made out? Please tell us, when is the contempt made out?
Your Lordship, it's regarding the your compassionate appointment, Your Lordship.
We are not on that. When, according to you, a contempt can be filed?
After the authorities has failed to
Fails to comply with the order.
Yes.
Correct?
Yes, Your
In your notice, you have not even told them that this order is to be complied with. What you have done is that 3/2 order you have enclosed and sent it. The requirement of the order is that you will have to bring you will have to intimate the person concerned that there is an order of the court which has been violated by him.
Yes, Lordship.
That notice you have not even given to them.
Yes, Lord.
Then give a notice and file an file an affidavit to bring it on record.
Yes, Lordship. Then liberty may be granted, Your Lordship. I will.
No, we are not dismissing it.
Yes, Lordship.
We are keeping it pending. You give a notice.
Yes, Lord.
You not like this letter at page 13.
Mm.
You have to say that there is an order of the court which has not been complied by you, and therefore we are giving you notice to comply with the order, or
Yes.
we'll have to impede you as a response
Yes, Lordship.
for violation.
So notice may be sent, Lordship.
Hmm?
Notice may be sent, Lordship. Yes,
Yes, you'll have to send.
Yes.
And file an affidavit.
Yes, Lordship.
Okay. You have Miss S. Somo. You have Miss S. Somo.
K.N. Manning.
K.N.
Maling.
Mani, then counsel for the applicant. K.N. Maling, then counsel for the applicant. Creates leave of the court to put the parties sought to be impleaded to notice to comply with the order of the comply with the directions contained in the order dated 26/8/2022, passed in WBC 287 of 2022. And to bring this notice to record by way of an affidavit, if prayer is allowed, the matter stands adjourned today, giving liberty to the petitioner to put the intending parties intended to be implemented to notice of compliance of the order of the court and to bring it on record by filing an affidavit.
Yes, obliged.
Your Lordship.
Please, may it please your lordship, I beg to mention item number 23.
In the contempt petition, you say, in view of the order passed in the connected IA Civil 126, this matter stands adjourned today. As and when the said interlocutory application is listed. And IA, you give a date after 4 weeks. Okay. Yes.
Your lordship, I beg to mention item number 23. And for the petitioner, petitioner has instructed us to withdraw the matter.
23.
Yes.
Your name?
Why Singhi?
Why Genie?
Singhi.
Singhi.
Yes, sure.
Why Singhi? Counsel for the petitioner, on instructions. Twenty-three. No, your name is not there in the cause list.
Yanum Singhi, your honor, your lordship, it is reflected in cause list. But it is in Wakalat Nama, your lordship.
Lordship, yeah, he is going to take the file that peon he is by
Oh, it
inadvertently.
has got inside. Okay.
Yes. He will be bringing now.
Okay. Item 23.
Yes, your lordship.
Just write down your name.
Yes.
All right, your lordship.
Ms. Sozo, upon instructions, submits that she has instructions to withdraw this writ petition. So prayer is allowed. The matter is dismissed on withdrawal. Yes. Yes, Mr. Ori.
Your Lordship, I beg to mention for item number 25, Your Honor, Your Lordship, and it is a cover matter, Your Lordship, and the same order has been set aside on the.
No, at 6 o'clock, we are not passing any order. At 6 o'clock, we are not passing any order.
Let this matter come up on Friday.
Okay.
For admission. For admission.
Item number 25. Okay, both sides are represented. The positive time matter could not be taken up today. List on so and so. Okay.
12.
Friday.
Friday, yes, 12.
Friday.
Okay.
12.
Any other matters would be left over?
Will you bless?